Out of the list.
My lords, a matter for 230. Matter moving for 230.
What is the urgency?
Has been executed, my lords. Wherein the warrant has been executed, my lords. Same has been ordered, and even child is also in custody of the petition itself, my lord. But even in spite of it, ex parte out of interim order has been passed. 30,000 they have made.
When was that order?
It is on, my lords, 14/7.
2:30.
Sir, Pawan advocate, sir, please. Sir, N. Pawan advocate, from your office, there is lot of disturbances to the court proceedings. Please mute.
Yes.
Serial number 102.
No, out of the list.
Out.
Serial list 3, serial number 1. It has become infectious. The party
List 3.
List 3, serial number 1. And for the petitioner, I have also filed memo for withdrawal in the office. Parties have obtained divorce. All cases have been withdrawn.
The memo is filed, seeking to withdraw the petition, stating that the parties have obtained a divorce. Yes, accordingly, memo is taken on record and dismissed as withdrawn. Yes.
107.
Serial number 34, list number 1.
List number 1.
34.
34.
The memo is filed, seeking to withdraw, stating that the petition has become.
List number 1, my lord.
107 has also become infectious.
107.
List
You mute him from here.
107, sir.
in list 1, my lord. WP 3771. Please.
My lord, list
Serial number 11.
107.
A memo is filed stating that the dispute between the parties in GNWC number 235 of 2020 is settled amicably. Hence, nothing suffices for consideration in this petition.
Before the Lok
Dismissed.
Adalat.
Before the law.
Please.
Serial number 101, some inconvenience today. We have also
No.
informed the other side, my lord.
No mentions for adjournment. I asked for any withdrawal, only that has to be mentioned.
114.
Serial number 11.
114.
Withdraw.
Yes.
114.
Okay. The petition has become infectious. Memo is done.
First list, serial number 11. Will be withdrawn.
Take that.
Purchase. First list, serial number 11.
Say, this withdrawal
My
petition.
lord, list 3, serial number 33. Memo for
Take that.
Lord, list 1, serial number 33, list number 3.
List number 3.
It is same matter settled between
List
the
1,
parties.
serial number
Memo is
55, my
taken.
lord.
Huh?
List 1, serial number 55.
55.
55, my lord.
Yes.
Decree of divorce has been granted by the family court, my lord.
55,
Filing the memo
yes.
for withdrawal.
Memo is taken on record. Yes.
55.
Serial number 166, my lord. Please.
No adjournments. No adjournment.
Both of us is present.
All of you there also adjournment.
Petition and respondent is for respondent. I had to file objections.
We will see. Only matters where there are settled and withdrawal.
That's what
Otherwise,
I seen.
This will be called. We can't, we will not adjourn the matters. Huh? On 26, finally 2 weeks time. It's a 2023 matter. When is it assigned to you? No, what is it you can do? Whatever are the papers on record that we will decide. Then why they are, without even giving papers to you, they have engaged.
they're not able to follow. So I requested that I will.
Whatever court's paper will be there, court will look into it and pass orders. Don't ask for adjournment, it's waste of time.
I'll just see.
A week's time, finally,
List number 1, serial number 70, my lord.
70.
Matter has to be heard along with the connected writ petition.
What is the number?
Connected case number WP 8876 of 23, my lord.
So post along with so and so on 6th of August. Yes,
Much obliged, my lord.
all these matters in list number 3 are referred to Lok Adalat, the mediation. List number 3, refer to mediation.
Lord, serial, list number 1, serial number 25, the matter settled in
List
mediation.
number 1.
Serial number 25, my lord.
Hmm.
The matter settled in mediation, my lord, before the family court of Davangere.
Hmm. Serial number 20,
25,
25.
yes, my lord.
Lords. Serial number 22, my lords, in list number 1. It has been infectious, my lords.
20,
22.
same,
Yes, ma'am.
infectious,
We'll file the memo.
yes.
Matlab serial number 30 in the third list, it will be referred for mediation in Shimoga matters because the parties are from Shimoga.
Oh,
Please.
in list number 3, serial number
30, matlab, 30.
30, it is submitted, the parties are in Shimoga. It may be referred for mediation at Shimoga.
Please.
Your Honor, list number 1, serial number 143.
Yes,
This matter was, this impugned order was appealed and heard at length in the family court recently. And in the last hearing 2 days back, the revised order has been posted to be passed on 21st of August of this month.
so then nothing to be, no further orders are required in this because it's an interlocked against an interim order. So final orders are already heard and the judgment is going to be pronounced.
On the impugned order. The writ petition here has been filed by the counterparty for the review of the impugned order. So on that same impugned order, the appeal was filed and it has been.
We will see when the matter comes what it is, then we'll adjourn the matter,
Your
not
Highness.
now.
Good morning, my
Yes,
lordship. I'm filing a memo posting for a writ petition which was filed by the opponents. There's an RPFC matter which is coming up tomorrow. There's an urgency because they've got a stay on the execution of the proceedings where this honorable court has only given liberty to.
I know, but that can't be, I know, I remember that case.
Right.
I only imposed a 25 cost in that.
Agree, my
It
lordship.
is, that a petition has to be allowed, no urgency for you, because they have no, the family court has no power to issue a lookout circular.
My lordship, when he has absconded from the country, what is
Please
the issue?
understand, it is not your problem, it is about the procedure.
Agree.
Family court has no such power to do it. It has no power, that's why you need not have any hurry for that. Ultimately, the petition has to be allowed. Yes.
My lord, list 1, serial number 89, my lord. I filed the withdraw memo on state of hearing kindly.
One?
List 1, serial number 89, my lord. Kindly 1 week
89.
time, my lord.
Why for withdrawal memo of 1 week?
My lord, party is any settled, kindly 1 week, my lord, please. I take instruction.
I said not to mention all this.
Kindly 1 week.
If I say once, you should understand. It's so embarrassing for the court to say no every time.
Yes.
89, next week.
Your Highness, serial number 125, list 1, my lord. The petition has become infructuous, may be
125.
withdrawn. Yes, please.
Yes.
My lordship.
Much obliged.
My lord, list number 1.
No,
May I make a mention
no
in list
adjournment.
3?
If it is withdrawal, you
My
can
lord.
tell the court. Yes.
My lord, serial number 3, list number 32, parties in Davangere, my lord.
Serial number?
3, list number 3, serial number 32, my lord. Parties are in Davangere, refer to Davangere.
Davangere, parties are in Davangere.
32, my.
My lordship, since you are aware of.
Your ladyship, list number 3, serial number 37. May I make a mention?
No adjournments, yes.
Can it be taken up tomorrow? I have a RPFC matter and the writ petition, can it be taken up tomorrow along
Yes.
with RPFC?
Take that post along with so and so.
Much obliged.
Your lordship, list number 1, serial number 113, the matter has become infructuous.
113.
List 1.
So write down the connected.
1.
It's written.
Written is that.
Yes. Infructuous, 113. Yes, call the list.
Your ladyship, I'm not looking for an adjournment. May I make a mention in list number 3, serial number 37, your ladyship? Some urgent orders are required. I would be filing an application if the matter may not be referred to Lok Adalat. I would be filing an application to recall with the leave of the court, if I may request for the matter not to be referred.
Delete 37 from
Great.
the list. Post it in the usual hearing. Yes.
May I request for 29th, Your Ladyship, subject to the convenience of the court?
Yes.
Serial number, list number 1, serial number 1, Ravishankar TP, for petitioner, Raju Bhatt.
For the petition, please.
Yes. Now, as far as the boy is concerned, will pass an order. He has to be, visitation shall go on. As far as the boy is concerned, as far as the girl is concerned, she needs to undergo the counseling.
But my lords, she doesn't require any counseling because my lords, she has witnessed to some incident which has been happened.
I can understand. That's what all she's saying.
Please.
The mother has played the conversation in between. Not that it is, these incidents have happened long back.
Please.
In between, she was talking to the mother. She was happily exchanging. Then she played the record. She didn't deny that it is not, it's not her. She says, no, don't. Like she is completely brainwashed, and all the time the father is telling her like how bad the mother is. That's not good. She cannot have those kind of ill feelings against the mother. And with that feeling, she cannot grow. She can't grow up like that. If the father could not, get her out of those, in that mode, that is something he is failing in his duty. He was also telling all narrating events before her. When she was very small, what happened? At 2 years, what happened? 3 years, what happened? At the age of 5, what the mother did. Is it right on the part of the father? Let them have 101 differences. But it's not right. How can the girl grow up like that with all those feelings against the mother?
No, when this incident was happened only in the year 2022. In 2022, she was around 12 years.
2022.
Yes.
And for 2025, it has become, now it is multiplied.
Yes.
From 2022, the intensity should come down at least 5%. Now from 2020 to 2025, it is multiplying, which is not good. Father is like all his emotions, she shouldn't carry. That's not her problem. If both of them are not liking, it's fine. But that's not the way the girl should be. And that's not in her interest. And it's a duty of the court to take care of her interest. And she needs counseling. She needs counseling. And if required, if she is going in the same environment, court has to take some other step.
But the children are happy with the father, and in fact.
Please understand, Mr. Counsel, that's not the submission at all. What is that? Why should they be? What is the boy is?
It is not that, my lords. The petitioner is not. Petitioner is always ready to.
That I can understand. I've seen so many parents. I met so many children. I can understand what is meant by happiness, what is meant by reluctance to meet the other parent, what is the advantages of a custodial parent. There are so many things that we have been seeing in so many cases.
Fact, my lord, she has any intentions of meeting the children, she could have filed petition much earlier in 2022 itself.
It is filed in 2022 itself, my lord.
Yes.
She has filed an application only in 2024.
When she requires counseling, any father, because that is not a kind of any stigma. No, mind is also part of the body. Like any other organ, it also requires some kind of treatment. It's not a treatment. It is a kind of stimulation that is required. Father is 100% reluctant to that because he wants his daughter to live with the same feeling about the mother. That mother is a big, a different character in her life. It is not right. He is not taking care of the interest of the child in that particular sense. Not providing them with food, providing them with facilities is not about the development of the child. So the boy, the small one, absolutely has nothing against the mother. He's so innocent. The sister is completely taking him for a. He's just carried away with what she's doing. He can't even. When I asked him, what is that so negative about your mother, or what you don't like about her, he's not in a position to say. He says, like when I remember, she was not allowing me to touch the things. That's the only negative thing he remember about the mother. He's such a boy for his age. Why should he deprive?
fact, with respect to the son, even I don't have any objections to.
No, what we do
Because
no, I'll pass
sometimes
an order.
he'll be very silent and sometimes he says, no, I don't want to meet my mother.
Because it's
That's all he
he's-
says.
He's carried away with the emotion of the sister. She is like that girl at that age. Is something not good for her. Those emotions or negative emotions are not good for her. It's a duty of the father to see that is neutralized. Not necessary. Don't go to the mother. That is a different aspect. We'll respect what her, but she is not in a position to know how she's completely now she's stepped into the shoes of the father. She started, visualizing or feeling what all the emotions father has, which is not required. Their problems, they will deal with it. Now I'll pass an order. The son shall be sent, whether he
Yes,
likes
sir.
it or not. He shall be sent. The son has to be sent with the mother for this visitation, as per the order, and the daughter, she shall
Like
go
it
through
may be
the.
modified for at least once in a month because he goes to.
No,
may
once in a
make
month. Once in a
because
month is not right.
at
Once
least twice in a
week.
month must.
No. Once in a week it has to be. Otherwise, how they will
But
develop the
because
bonding?
he's going to some extracurricular activities wherein he has to attend that
Submission,
and
the
along with
submi-
this
No, the submission,
academics.
I'm not able to understand from any of the parents. What do you think that, more than the, love and affection of the mother and more than the relationship, which is a basis for a complete holistic growth of a child, academics is more important, extracurricular activities are important. They're only 30%. The remaining 70% is this, which shapes them into a good
Human being.
independent human being. So this boy has to go every week, and this girl has to go on any of the convenient day to that girl, where you want it in hands. I can send it to, or some other counseling. You say wherever it is.
Some other psychiatrist will.
Please, you only tell the court. I'll pass name that counselor, and I'll pass an order.
I'll take instructions. With respect
Instructions.
to
I'll
that.
post this matter tomorrow, but tomorrow I'll pass an order as far as the boy is concerned, that he has to.
Not tomorrow,
And
ma'am,
if
Monday.
take this, list this matter on Monday. By the time the learned counsel appearing for the father and as well as the mother shall get specific instructions with regard to the psychiatrist, which is nearer to the place of the father, because the girl is residing with him. And as far as the boy is concerned, the court will be passing orders for visitation on the next date of hearing. List this matter on Monday.
Great.
Please.
For dismissal, serial number 2, SP Shivanand.
Earlier, I'm appearing for the respondent, my lord. I already, this matter is pertaining to Legal Service Authority, my lord. I returned the file on.
Is as listed today because there is no representation for the petitioner.
Please, ma'am.
This RPFC of the year 2017. On the last occasion, on Come here. Where is this order with regard to this obtaining from, look at the cost item. Where is that? But then how he was permitted to appear and interim order is granted? The office has issued the notice to the party in person to obtain the, to appear before the party in person committee and to obtain the necessary permission. It has been communicated to the party in person, and so far he has not taken any steps. The matter was listed on 23/7/2025 as no representation. The matter is listed today for dismissal. It appears that the party in person is not interested to pursue the matter. Accordingly dismissed.
Cell number 3, KP Bhuvan.
My lord, a week's time may be given, my lord. I have sent notice to this petitioner, my lord. My lord, the petitioner is unable to contact my lord. Hence, I have sent notice to the petitioner, my lord.
By 23/7/2025,
Yes, my lord.
if the order dated 28/5/2024 passed by this court is not complied with and the receipt is not produced, the revision petition shall stand dismissed without further reference.
My lord, here what happened, my lord? After 25 years delay, my lord, this criminal misdemeanor petition filed, my lord. They obtained the ex parte order, my lord.
What will happen to the order of the court dated 23/7/2025?
Weeks I will pay.
No weeks time.
My lord, I will pay and file the receipt, my lord.
I have already given you enough time. On 28/5/2024, an order was passed.
Trial court order, my lord, clearly mentioned, my lord. They have married on 1994, my lord. Only
The
1 year
council,
they
we are
lived
not going
together.
into the merits of the matter. You have to comply with the order. This is passed on 28/5/2024. I have given you another opportunity on the last occasion. You are again saying the same thing. Why the court has to hear all this?
No, no, my lord. Only 1 week, my lord. I was sent already notice to this petitioner, my lord.
28/5/2024, an order is passed, whereby
My lord,
the application is allowed on the cost of rupees 5,500 payable to the advocate clerk's trust, and the delay of 889 days in filing the petition is condoned. Even till 23/7/2025, even after an year, that amount is not paid. Then on 22/7/2020, not 23, 22/7/2025,
submission today
the amount is not paid. Then on 22/7/2025, this court has passed an order that by 23/7/2025, if the order dated 28/5/2024 passed by the court is not complied with and the receipt is not produced, the revision petition shall stand dismissed without further reference to the court and directed the matter to be listed on 24/7/2025. Even today, when the matter is called, land council submits on the merits of the matter and submits that he has addressed a letter and it seeks a week's time. When an order is passed as back as on 28/5/2024, till 22/7/2025, the order is not complied with. And again, even after granting time, the submission of the council that he has to contact the party or a communication is sent to the party cannot be accepted, and the petition is dismissed.
Cell number 4. Cell number 4, we are Dhananjay.
This RPFC of the year 2022, this is listed before this court on it is listed before the court on 9/2/2022, 18/10/2022, 10/11/2022, 3/8/2023, and 23/7/2025. On all these days, at least on 3 occasions, there was no representation, and on other occasions, court has permitted the petitioner to comply with the office objections. The right from a petition of 2022, it was never heard, and the petitioner has not complied the office objections. When the matter came up on 23/7/2025, again giving another opportunity to the petitioner, again giving an opportunity to the petitioner, this the matter is adjourned to today, and then the list directed to list the matter under the caption for dismissal. Today also there is no representation. It appears that the petition is not interested to pursue the matter, accordingly dismissed.
Cell number 5, RB Deshpande.
Sorry, ma'am. It's a wife's petition.
Yes.
It's a wife's petition
Hmm.
seeking maintenance for her daughter, my 5 months daughter, and herself. The trial court has rejected the maintenance to the wife on the ground that for restitution of conjugal rights, there is a decree in spite of she herself has deserted from the husband. But only 3,000 rupees has granted to the child.
Please come to the info note.
Please.
Operative portion, let's see the operative portion.
Operative portion at page 39, madam. 125
Petitioner
here.
number 2 is entitled so and so. Petitioner number 1 is hereby rejected.
Please.
Already the restitution petition is ordered.
Ordered.
So there is nothing to go into that order. Now, what is the income of the husband?
Husband is, he's a gardener, my lord.
Gardener.
Gardener, 9,500 salary and telling. And he owns 2 acres. I have produced RTC. Out of which 1 acre Arekanat land. Arekanat Galada.
How much?
Now
income
3,000 has been ordered to the.
No. When you say that he's having 1 acre, how much amount? What is the income from the land?
That is not filed, my lord. Liabilities and affidavit.
Because when you say 9,000,
Please.
3,000, what is granted is correct. Salary, looking at the salary.
Now he's 6 years old, man. At that time, 5 months. He's going school going.
Another 1,000 will increase. The agreed with the orders passed in. Criminal miscellaneous. 67 of 2019 dated 9 December 2021. Whereby the court had granted an amount of rupees 3,000 to the daughter, and the claim of the wife is rejected. The wife is before this court. The wife had filed a petition seeking maintenance for herself and for her daughter. It is a case that is having landed properties and is capable of paying maintenance of an amount of rupees 20,000 each to the wife and the daughter. It is a case of the husband that is working as a gardener and earning 9,000.
9,500.
Earning 9,500. And he cannot pay the maintenance as sought for by the wife. And he is not having mobile or immobile of his own. The court, when it comes to the wife, court had dismissed the application for maintenance as the MC that's filed for restitution of conjugal rights is allowed, and wife had not joined the husband. As far as that issue is concerned, this court is not inclined to interfere, as the said order rejecting maintenance to the wife is a well-considered one, as the MC filed with the restitution is allowed, as she is staying away from the husband without a reasonable cause. Then coming to the daughter, the husband is earning an amount of rupees, according to him, 9,500. What are the documents filed to show that he's having?
Except RTC, I have not put in.
The wife had filed the RTC extracts, that is
Exhibit P4.
Exhibit P4, to show is having agriculture property of an extent of
2 acres.
2 acres. Though there is no evidence what would be the income that he is deriving from the said property, but he would be deriving the amount apart from the income, apart from this, apart from the salary he is receiving working as a gardener. In that view of the matter, this court deems it appropriate to modify the order of the family court. Accordingly, so and so is modified. And as far as the wife's case is concerned, this court is confirming the order of the family court. As far as the daughter is concerned, the same is enhanced, the maintenance is enhanced from 3,000 to 4,000.
Much.
In the matter, when the matter is there is no representation on behalf of the respondent. Yes, ma'am.
This case, my lord, parties has been reunion, my lord.
Parties are living together.
Reunion, my lord. Parties are
that is-
agreed to living together, my lord. But what type of settlement has been done, I don't have information, madam. I'll have it on Monday. I will make our submission, madam.
List this matter on Monday. Let council submits that parties are living together, and you get instructions in this regard. Yes.
Serial number 7. 7. Nagaraj, yes, sir.
As there is no representation on 23/7/2025, the matter is listed today and the caption for dismissal. Today also there is no representation. Okay. Yes.
Serial number 8. Serial number 8. Vishnumurthy.
Sorry, Your Lordship, challenging the order passed by the family court, Your Lordship, that awarding the maintenance of rupees 20,000, Your Lordship.
You are for the husband.
Husband.
Where is impugned order?
Is-
Impugned order, page number.
In page number 35, Your Lordship.
Petition is entitled for maintenance of 20,000 and 10,000 for litigation expenses. What is the income of the husband?
He is a disabled, Your Lordship, dumb and deaf, Your Lordship, that only 1,400 was given by the government, Your Lordship, that because the parents are taking the
That
care.
is recorded by the court. Please come to the reasoning part.
But he was admitting that in the cross assumption that the family maintenance there, he was capable of giving, because some.
No. Where is, in which paragraph of the order, court has recorded with regard to his handicap, that he's an handicapped person.
Yes, the expert was, in the cross assumption was mentioned, Your Lordship, that expert was called by the principal of the dumb and deaf, and.
The paragraph, let us read.
Your Lordship, that it is undisputed fact, Your Lordship, that. The para 8, Your Lordship, that the respondent further contended that he is deaf and dumb and he studied up to 7th standard in a normal school. At the time of marriage, the petitioner was informed regarding the respondent and being a deaf and dumb. After 2 months of deliberation, the petitioner has agreed for the marriage alliance with this. It is undisputed by the classrooms also, the learned magistrate was recorded that regarding.
What he is doing? What is he doing? Occupation.
Occupation earlier he was doing shop, your lordship. That later on he is unable to do that one also. And 1,400 was given by the government for a disabled person, your lordship. That. And after divorce, the maintenance was filed, your lordship. That. The divorce was recorded, your lordship. The decree was divorce was passed on 28 2019. Thereafter, this miscellaneous was filed in the year 2019.
What is this? RW in his cross-examination had categorically admitted that his joint family is having income of 30 lakhs to 40 lakhs every year.
But some of the admission, because it's a different term, you is not understanding what is the translation is. You are regarding the harassment also, you is admitting that the cross-examination will also that's what means that my contention also, you was not understanding properly what is the this one, your lordship, that or properly accorded this one, different term you because of that. Regarding harassment also, he is admitting. Maximum, whatever the suggestion he was, everything is admitted because it's not understanding properly that evidence was recording. That's my condition.
Then file an affidavit in that regard.
Please, your lordship.
Before the court, it is admitted that the petitioner husband has admitted that his joint family is having 30 lakhs to 40 income of 30 lakhs to 40 lakhs every year. And it is also admitted that he is having the capacity to pay 20,000 per month as maintenance to the wife from the income of the joint family. The learned counsel, the petitioner submits that the petitioner is a deaf and dumb person. He is not able to understand what are the suggestions that are given to him, and everything is accepted. He also accepted about the harassment, and he accepted everything that is suggested to him. Considering this, the petitioner shall file an affidavit before this court with regard to what are the joint family properties that are standing, what is the income that is derived from the said joint family properties.
Please,
in the form of an affidavit.
Please,
A date may be fixed, my lords. I am for the respondent in this matter.
And yes, your lordship.
A date be fixed, my lords.
Is this matter on 14th of August?
Please,
Not 14th?
Please.
12th of August.
Please, ma'am.
Please, please.
Appearing for petitioner now. In present petition, we are challenging the order passed by the family court, my lord, on 11 April 2023, my lord.
Please come to the order.
Page number 19, ma'am.
The petition filed with the petitioner is dismissed.
Yes, ma'am.
Please read from the reasoning part.
In this petition filed by the petitioner husband under section 125 of CRPC for grant of maintenance at the rate of 25,000 per month. The brief averments of the petitions are as follows. The petitioners and respondent are husband and wife. Their marriage was solemnized on 2/5/2021 at Saralabalu Kalyana Mandapa, Harapnalli. Out of wedlock, 2 female children are born to them. The petitioner and respondent led cardinal marital life for some years and for the convenience of the respondent. He has set up a house at Davangere. The respondent, on the ill advice of his father and sister, started quarreling with him and was not discharging her duties as a dutiful wife. In spite of it, keeping in mind the future of the daughters, he has tolerated all such harassment meted out by the respondent, and due to said act of the respondent, he is suffering from diabetes and blood pressure. The respondent used to say that he is not a matching pair to her, and that she has married him only at the instance of her father, and she is not ready to let the marital life and even to share the bed with him. In spite of panchayats and advice given to the respondent, she did not mend her ways and left to her parental house. His bona fide effort to bring back the respondent and the children went in vain. The respondent, through the daughters, had filed a OS number 16/2023 seeking maintenance, wherein 4,000 each per month is awarded, and she has filed an execution petition for recovery of maintenance amount. The petitioner, with an intention to...
You're working as a government teacher.
Yes, my lord. Both are...
Account maintenance.
He is suffering from some kidney problem, my lord. Already once kidney replanted, again he has a kidney failure problem.
No, the husband has filed the...
Yes, my lord.
For seeking the amount from the wife.
Yes, my lord.
He remarried?
No, my lord. No, my lord.
That's what is his case. He has children out of the second marriage. How can he seek the maintenance from the first wife?
My lord, the petition filed by the wife in CC number so and so, my lord, stating that he is having a second marriage.
He also admitted it.
No, my lord, it is not true.
Come to that. I've seen it. Read para number 11.
During the course of the cross-examination, the petitioner PW1 has admitted he is working as a teacher in government school at Ujjappa Vodera Alli and drawing a monthly salary 35,000, and that he is taking a treatment at Kasturba Manipal Hospital. PW1 has further stated that the medical expenses can be reimbursed from the government. The PW1 has admitted that he has taken second marriage, and out of the said wedlock, there are children.
How can you maintain this petition? How can you maintain? We'll dismiss it with cause.
My lord, but the petitioner is suffering from some kidney.
How was a divorced wife has to maintain our husband who has already married? Please come.
Lord, kindly give a short accommodation.
No, sir. Agreed with orders passed in criminal miscellaneous number 213 of 2021, whereby the court has dismissed the application filed by the husband seeking maintenance from his divorced wife. The present petition is filed. The petitioner husband has filed a petition under section 125 CRPC for grant of maintenance of an amount of rupees 25,000. It is his case that he is suffering with kidney disease and he requires money for his maintenance. The admitted facts are both the petitioner and the respondent, that is the husband and wife, are working as teachers. The petitioner has obtained the divorce from the respondent wife. After that, he has contracted the second marriage. Out of the wedlock, he has children. In these circumstances, the petitioner has come up with this petition. The court had dismissed the said petition, observing that PW1 has admitted that He's getting rupees 35,000 per month. And he has admitted that he has undergone kidney operation and his entire medical expenses are reimbursed as he is a government servant. And moreover, he has admitted that he was reimbursed some major expenses spent towards medical expenses. That is 4,80,000 from the government. And also admitted that he is getting rupees 35,000 per month. And as per the statement of assets and liabilities, the salary is shown as 41,000 per month. The court has come to the conclusion that under the circumstances, the petitioner here can maintain himself and also he can meet the medical expenses out of his salary, and through medical reimbursement, he is already getting the amount. Court has also observed that, that he has obtained the divorce and remarried, and out of the said and in the said wedlock, they have children. The court had come to the conclusion that the petitioner has failed to prove that the wife has willfully refused or neglected to maintain him in spite of having sufficient means and is entitled for maintenance, and accordingly rejected the petition. Learned counsel appearing for the petitioner submits that petitioner husband submits that the court, without considering the fact that he is suffering with several health ailments and he require the maintenance, had dismissed the application. It is submitted that wife is having sufficient income to maintain him. Next para. This court has perused, having heard the counsel for the petitioner, perused the order. The court has gone more on the fact that the husband is having sufficient means. But the important aspect in this case is the husband who has remarried and having children, who has divorced the first wife, how he can seek maintenance from the first wife is a question, and is not entitled for maintenance under 125. Apart from that,
he has filed a MC petition before the family court also, my lord. Already has obtained that divorce also.
that's what I'm saying. I'm saying that the court and the court on the other aspect also, where he is getting the medical reimbursement and is having sufficient income, has dismissed the petition. At any stretch of imagination, the petitioner is not entitled for maintenance from the wife. Accordingly dismissed.
Then number 10. G.H. Srikantegowda.
For the petitioner in this case, kindly have it tomorrow or on Monday, my lord. I'll be submitting the settlement which has been happened before the lower court. So I had contacted the petitioner on the last date only, my lord, but he had not approached. Today morning he has contacted and he'll be coming for today.
It is settled.
Yes, my lord, it is settled.
I'll record it.
I'll produce it tomorrow, and my lord,
Required.
I don't have any information. Only they have telephonically
If it
stated
is there, then learned counsel for the petitioner submits that the matter is settled, and he'll come up with an appropriate petition. As it is submitted that the matter between the parties is settled, this petition is dismissed as infructuous. If the same is not settled or there are any other instruction, he can come up with an appropriate application seeking to revive this petition. Yes, dismissed.
Cell number 11. 11 disposed. 8-12. Cell number 12. Mamata Ji.
In this matter, NOC has been already given, my lord. We'll file a memo for retirement.
If it is given, you should have filed it.
We have to
It's a
file.
writ petition of
Even, my lord, the MC petitions, my lord, this writ petition is filed seeking transfer and clubbing of two MC petitions. Even that petitions got disposed.
Then with that we will record.
We'll make a submission, my lord, with memo for retirement, my lord, maybe taken up in
The land council seeks time to file the memo of retirement. The present petition is filed to transfer What is this relief?
Even
Fifth
we have
additional-
written the file.
No, prayer. Fifth additional principal judge family court at
Understood.
Bangalore,
I saw that.
which is pending consultation transfer to principal judge family court at Tumkur district. What is this prayer?
I'm my friend's matter, my lord.
The MC number 322 of 2021 is filed on the file of the family court at Tumkur, and MC number 5285 2021 is filed. You have to file a CP. However, writ petition is
Yes.
maintainable first.
Yes, my lord. Even I'm a proxy counsel, my lord. I saw the prior, my
That
lord.
round I will dismiss. The present petition is filed seeking transfer of an MC that's pending on the file of the family court at Bangalore to the family court at Tumkur. The a writ petition for that purpose, the petitioner cannot file a writ petition. He has to file a CP. Then counsel the petitioner submits that he'll file his that they have given no objection, whatever it is. When the petition itself is not maintainable, this court cannot pass any orders accordingly dismissed.
Cell number 13. Omkar Sharif for petitioner.
Correct for the respondent, my lord.
Read up.
Intermodal is complied with.
Your lordship, he has paid from the date of order passed by this court, but earlier to that, whatever the arrear is,
Not ordered.
no, my lord. Because that was ex parte, my lord. Before issuance of notice, that order was passed by this.
This matter came up on 23/7/2025. As there was no representation, the matter is directed to be listed in another caption for dismissal. Today also there is no representation. Accordingly, the matter is dismissed for non-prosecution. Next,
Number 14.
the counsel for the respondent is present.
Swami Shivanand Prakash.
Here for petitioner, Your Honor. Seeking for short accommodation.
No
my lords.
accommodation. Have to argue the matter, pass over. Please look at the file.
I will argue.
Yes, pass over.
Cell number 15.
For respondent, my lordship. Petition. It's a common order passed by the family court. Page number 3, 4, and 5, my lord.
Page number?
Page number 92 is operative portion of the order. Total 93 pages order is there.
For an IA.
Yes, ma'am. The AA number 3, 5.
Portion is where?
Pardon?
Operative portion is at page number?
On page number 118, ma'am.
Hmm.
118.
IA number
IA number
5.
3 filed by
Who filed the MC?
MC filed by the husband, ma'am, petitioner. Now the wife filed the application, and the two application, one is to direct the petitioner to pay the educational expenses, another one maintenance. Now the trial court ordered to pay the entire educational expenses apart from 30,000 per month as a salary, as a interim.
10,000 to the respondent and 2 children.
Yes,
Aishwarya S and Mas. In total 30,000 per month.
yes. The A number filed by the.
Pay some 50,000 towards education expenses.
Yes.
So allowed in part. What is this IA number 5?
IA number 5, section 26 of Hindu Marriage Act, visitation rights, ma'am.
Is directed to produce the
Yes, children are custody in the wife. But till today, the respondent has not complied the orders. Even whenever the husband is interested to see the child, simply says that the children they're not interested to see the father. They sent the message from last 2 years.
Then
Even
what did you do?
now we have requested the advocate also in the court.
Requesting the advocate.
Yes.
You have a remedy.
Yes.
Why this
Filing.
requesting business will not work. You have
Yes.
to do something.
Yes.
And you should have you brought it to the notice of the court by filing an application.
Yes, second option is when the father went to the school to deposit the amount, the school amount, then they filed the application for stay application to restraining the father to not to visit the school also.
That is ordered.
No, ordered.
Have you questioned it?
No, my lord, because their very intention only to dispose the matter the earliest possible, because we are ready to pay the 30,000 per month without a.
MCs of which year?
2020, my lord.
Which court it is?
Principal family judgment.
Principal family judge.
Yes, ma'am.
Will direct this court to dispose of the matter by 2026 April.
End of the December.
No,
No,
December.
because last 2 years, they took the time for cross-examination.
They are busy with 2019 matters. 20, they will start from December 15.
Please.
We'll say April.
And liberty to file the petitioner to file the application for modification.
What
Like
modification?
since 2022, he has no job.
Why should we give the liberty now?
File the application for
Still
modification.
pending, whatever it is, pursue there. The present writ petition is filed.
Yes.
My lordship, principal family court has been ordered for 50,000 per month.
30,000 per month.
50,000 I guess.
30,000 maintenance, 50,000 litigation expense.
Litigation expenses.
You don't do what you're supposed to do. You want his money, but you will not show the children to him.
We will show.
And then I'll keep it, show tomorrow, the
Tomorrow not possible.
father shall meet the children.
Please.
Or else I will set aside this order.
Direct the
No,
parties to keep the children.
Not present,
No.
let them meet.
Next
What
week,
is the age of the
next week, my
children?
lordship. Next week.
What is the age of the children?
The 9th standard.
One
on
is
the
9th standard, one is 6th, 5th standard, 4th.
The father is permitted to meet the children. Where do they stay?
The cost on Bangalore only.
Bangalore. So what is the distance between both the places?
15,
Your place, huh?
15 kilometers.
What is the nearest mall there?
The mediation center itself.
Bangalore mediation.
Bangalore mediation.
The father shall meet the children in the Bangalore mediation center on which date?
Saturday, Miller.
On Saturday at
10 p.m. 10 a.m. Sorry.
they may be having school
Saturday holiday. Ma'am. That's
holiday.
Holiday.
We'll say at 4 o'clock, that would be 3 o'clock would be convenient.
No.
Between 3 o'clock and 5 o'clock,
Yes.
the mother shall get both the children. If by any chance, if the mother fails to attend get the children to the mediation center, the court would be left with no other opportunity but to allow this writ petition. Before this line, learned counsel, the petition submits that in spite of an order passed by the court, the mother has not shown the children till now. He could never exercise the visitation as per the order of the family court. And it is submitted that he has been paying the maintenance, but he is not permitted to see the children. Yes, basing on what transpires on the day, further orders will be passed. This matter on 1st of August.
This Saturday is leave, so next Saturday, my lordship.
This Saturday.
This Saturday is 4th Saturday.
Mediation center will not be there.
Mediation center what?
No problem.
No problem.
Yes.
Cell number 16, T. Sheshgiri Rao, and Suresha.
So petitioner in this matter, your lordship, in this matter, we seek for short accommodation.
No accommodation.
Your lordship, the senior is out of station and have no clear instructions in this matter. I
Why
pray
you-
for a very short accommodation, your lordship. Kindly, it may be had on Monday.
From now onwards, the matters which are listed in dismissal, sought for adjournment, will impose the cost so that this practice would stop. This is matter on 29. Further adjournments will be granted. Yes, 17.
Cell number 17, Zamir Pasha, for petitioner.
Same matter came up on 23/7. That day and even today, no representation on behalf of either of the parties. Yes.
Cell number 18, Girish Kumar CS.
Same 23/7.
Cell number 19,
Petitioner filed Mela. The petition about the family court under section 25 Guardians Rights Act Mela, seeking the custody of the minor child.
Where
From
is the
the
impugned order? Page number?
page number Mela, annexure A Mela. Annexure A Mela. The trial court has
Guardians and Advance Act is dismissed.
yes, Mela. Application interim relief the custody of the minor child. The came to the application dismissal.
Let
The
us see.
trial court referred to the annexure B condition number 5 Mela.
Next year.
Annexure B, mediation report mila. Annexure B mila.
Let us see the first this order. Read from the reasoning part.
Yes mila. Page 17 mila. Page 17 and in para 8 mila. On the other hand, the regard a memorandum of the settlement was taken place in between petitioner and the respondent dated 23/2019. Later, the said memorandum of the settlement was culminated into the decree and that was drawn 23/2019. Therefore, the matrimonial dispute was completely resolved. Apart from the decision also made about the custody of the child in concern the regard point number 5 of the settlement agreement in material, it is discussed as under. It has been agreed that a sum of rupees 3 lakhs as permanent alimony and also maintenance with regard to the minor child who is in care custody of the mother, the petitioner, and it has been agreed that the permanent custody of the child shall continue the mother petitioner. In case the child wants to see respondent, the petitioner shall not object the same. The respondent filed the objection, Miller. The respondent expressing the problem granting the temporary custody of the petitioner because he's saying the petitioner is having the several habits. Apart from this, is living his second and wife and children. Therefore, the court will the said apprehension. The respondent would not be ignored the
What is the age of the child now?
child, Miller. The child born on Miller.
No, you already said, you have already signed this memorandum.
Miller.
MOU signed. It
Yes,
is
ma'am. Yes,
no
ma'am.
final.
Yes, ma'am.
No, contrary to this, how can you ask for this?
Miller, please see the paper book, Miller, para number 3, Miller.
Para number 3 of what?
The petitioner further only submit that subsequently disposal of the MC petition, the petitioner on several occasions had requested to the respondent to allow him to visit his minor child.
What is the clause in that? There is no, you didn't ask for visitation. What you said was, in that, who asked you to enter into an agreement like that?
Agreement number annexure B5, Miller.
Now please look at it. It has been agreed that a sum of rupees 3 lakhs as permanent alimony with regard to the minor child who is in care and custody of the mother. And it has been agreed that the permanent custody of the child shall continue with the mother petitioner in case the child wants to see the respondent. The petition shall not object to the same. What is this clause? Please come. Agreed with orders passed in GNWC number 48 of 2020 dated 2nd September 2022 dated 2nd 2022 in I number 2 in GNWC number 48 of 2020. The petitioner is before this. The petitioner father is before this court. The father has filed the IA under section 12 of the GNWC Act seeking direction to the mother and for protection of the minor child for the temporary custody or minor and for the visitation rights on every Sunday. The court has rejected the same. While rejecting the same, the court had considered the memorandum of settlement filed before the court in MC number 594 of 2018, particularly clause number 5, as per this page number 21, extract clause number 5. As per clause number 5, the father has completely given up his visitation as well as the custody rights, and as per the same, whenever the child wants to see the father, the mother shall not object. Now, the contrary to the terms and conditions agreed, no, the present application that is filed seeking visitation and interim custody. Even the court has interacted with the boy, and the boy has said that he is not interested to see the father. The court has rightly observed that in the light of the said memorandum, the visitation has dismissed the petition. The court ought to have granted the visitation, considering the welfare of the child. Next part. This court has heard the arguments of the counsel and also perused the order. The court had rightly considered the clause number 5 of the memorandum of settlement entered into between the parties in MC number 594 of 2018, and also had interacted with the boy. And in those circumstances, court has rightly held that the IE that is filed cannot be entertained and dismiss the petition. This court finds no reasons to interfere. Accordingly dismissed.
Cell number 20. Shama, yes, sir.
Matter came upon 23/7. Dismissed.
Cell number 21. Devendrappa.
Needful has been done, my lord.
It is submitted that the needful is done. List this matter after service of notice. Delete from the caption dismissal. All the matters delete it whenever there is a. Yes, next.
22 disposed. Cell number 23. Student BS.
The senior's father-in-law is really sick and we've not been able to appear because of that. We seek a short date, just Monday, my lords, will come make our submissions. Seek a short date, just Monday, my lords, will come make our submissions.
Tuesday, no further adjournment.
Obliged, my lord.
Shall be under the same caption.
Cell number 24.
Petitioner, my lord.
Ready?
In the main matter, my lord, the negotiations are going on. Why
For a
file the-
settlement, negotiations are going on.
In the MC
Your Honor, may
petition.
kindly give us a short accommodation, we'll report settlement.
Week's time is granted. It is submitted that negotiations are going on. Let's this matter on.
4 weeks time maybe.
No, 4 weeks.
No,
Do
it's
it
referred to
before-
mediation.
Before the trial, mediation it is. When is it referred to the mediation?
It's next date it will be referred to the mediation, given the proposal.
Yes, in MC.
Yes, please.
Where it is pending, in which mediation?
No, it is not referred to mediation as such. They have just given me a proposal. I'm yet to accept it, post which I will report to the settlement.
This is matter on 19th of August, no further time. It is submitted that the settlement talks about.
With the lordship's kind leave, could it, how, Your Honor, your lordships have it on the 20th or further date?
20th. Yes.
Much obliged.
Cell number 25 disposed. 26. 26 Syed Ibrahim Anwar.
On 2/6/2025, 18/6/2025, and again on 23/7/2025, there is no representation on behalf of the petitioner. Having given several opportunities, again finally on 23/7/2025, the matter was directed to be listed for dismissal as there is no representation. Today also there is no representation. Same, not interested to process the
Cell
matter.
number 27 Ramesh Gowda MP.
Wife's criminal mispetition for maintenance, interim application at page number 17. Lordship. The wife has filed a petition for maintenance and interim maintenance.
Who filed so is partly allowed. The respondent is directed to pay interim maintenance of 10,000, and so 15,000 is awarded. Yes, your wife is before this court or husband?
Husband.
What is the income?
She has voluntarily taken the child and filed this petition. In fact, husband has filed a petition for custody of the child and arrest.
What is your income? That's how we can.
Income. He is working in a brick factory. He is getting only 20,000.
Let's look at the order.
India, they have made allegations that they have
Not
got landed
allegation.
property.
How the court had,
The counsel for the petitioner submitted that the first petitioner is aged about 37 years and since from the date of marriage, the respondent is not allowed to work. Therefore, she is not having work experience in order to secure job. And at this stage, it is difficult to secure job. Due to matrimonial problem, she is mentally upset and she is entitled for interim maintenance. On perusal of the petition, address of the respondent is shown as Bangalore. Therefore, Since from the date of marriage, the first petitioner resided with respondent till she separated from him. It is not the case of the respondent that prior to the marriage, the first petitioner was working and can work and earn based on her educational qualification. According to the respondent, first petitioner left the matrimonial house on 5/7/24. Therefore, considering the duration of separation, as she has to adjust and to come to the normal life, it will take some time. Therefore, the respondent is liable to provide the basic necessities to the petitioners. The petitioners have averred that the respondent is having vast landed properties, doing agriculture and earning more than.
Which court is this?
This is Kolar, family court, Kolar. There are no landed properties in his name, petitioner's name, Lordship.
Take this judgment, give it to Registrar R&S. The present petition is filed. Agreed with the order dated 22nd March 2025. Passed in criminal miscellaneous number 140 of 20 in IA number 2 in criminal miscellaneous 20 in IA number 2 in criminal miscellaneous number 140 of 2024. The court had granted an amount of maintenance of an amount of 10,000 per month to the wife, 5,000 to the daughter, altogether
Son, my lord.
son, an amount of rupees 15,000. And the father is directed to pay 75,000 per annum in one lump sum towards the educational expenses. This court has perused the order. In the entire order, there is no discussion about the statement of assets and liabilities, directions issued by this court. The courts are not strictly adhering to the law laid down by the Honorable Apex Court in Rashish versus Neha. In this case, the court has failed to follow the law laid down by the Apex Court. Considering all this, the interim order, according to you, what is your income?
20,000.
The petitioner, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 10,000 towards so and so, and the arrears also at 10,000. Anita, send this to R&S. Today itself. Ask him to talk to him. Yes, next. Notice to respond. A petitioner is permitted to take out hand summons and file a memo to the effect by 13th of August, or else even on that ground also, stay granted by this court stands vacant. Yes.
Okay.
Delete from the caption. Stay granted by this court stands vacant. Yes.
Okay.
Delete from the caption dismissal.
For orders matter, still number 28.
For the
Still
petition in
number
this case,
28.
my lords. Lords, there is no instructions from the petitioner. When we talked to him in the last occasion, my lords, we contacted his brother-in-law. We were instructed that he is not well, he is bedridden, my lord. The petitioner is bedridden. His brother-in-law instructed us that the matter is been settled. Already been. Law instructed us that the matter is been settled. Already been settled. We further there is no instruction, my lord. Yesterday also, before 2 days, we tried to contact them.
That I'll record.
Please, my lords.
That I will record.
Please, please. my
Then
lord.
counsel the petitioner submits that they could not contact the petitioner as he is bedridden, and his brother-in-law of the petitioner has informed the council that the matter is settled between the parties. Recording the same, the submission is taken on record, and the petition is dismissed if the dispute is.
Be kindly allowed, your lordship. In this matter, no execution proceedings has also been filed by the petitioners or the respondent in the family court, and we are seeking for the enhancement of the maintenance.
Who will file the execution? You are for the wife.
We have to file, your lordship, but we are waiting for the enhancement of the maintenance in this.
Where is this recalling application?
Your lordship, we have filed it on 16/6 of 2023.
I number 1 of 23 is filed to recall the order dated 3/3/2023 passed with the registrar protocol for non-prosecution of the office objections. Then I number 2 of 23 is filed to condone the delay of 171 days in filing the application to recall the order dated 3/3/2023. In support of the application, it is stated that the matter was listed on 3/3/2023 before the registrar protocol. As they could not appear on the day, the same was dismissed for non-prosecution. It is stated that the petition is staying in Davangere and she could not contact the council on record and furnish a few documents to comply with the office objection. Hence, in the process, a delay of 171 days occurred and it is neither willful nor wanton is also allowed. The petitioner shall comply with the office objections within a week. This time it will not be recalled.
Please, Your
without order,
Please.
or else the petition shall stand dismissed without further reference to the court. Next.
Cell number 30, Krishna Reddy R.
No representation for dismissal tomorrow.
Cell number 31, Rajesh Gowda.
The respondent residing in the same address as mentioned in the order in page number 11, and she's also filed a execution petition before the trial court, and we filed the application before stating that there's a stay before the Honorable High Court, and permit me to serve the counsel before the trial.
Then counsel, the petition is permitted to take out hand summons on the counsel appearing for the respondent before the executing court and shall file a memo to that effect by 7th of August, or else the petition shall stand dismissed
Interim order may be extended.
without further reference to the court. Interim order earlier granted is extended till then. Yes.
Great.
Number 32,
No representation.
Vinay Swami.
And for the petition, the matter has been settled. However, we tried to cross-verify with the client, but we couldn't get in touch. It may be posted in the next week, I'll withdraw the petition. If such
I'll
need
record
be.
it.
Yes, ma'am.
The land counsel, the petitioner submits that the matter is settled out of the court and they'll come up with an and yes, and he'll come up with an appropriate application to withdraw the petition. Considering the fact that the dispute is already settled, the petition dismissed as infructuous. However, if anything survives for consideration, the petition is at liberty to file an appropriate application. Yes, next.
Cell number 33,
Appearing for
This
the
matter
petitioner,
after service of notice.
appearing for the petitioner, my lord.
awaiting sir.
Liberty was granted by this honorable court to serve the copy to the counsel appearing before the trial court. We tried to serve the copy on 27/3 of 2025, my lord. I have filed a memo dated 4/7, wherein the trial court has recorded about the serving of the copy, and I have produced the trial court order copy, my lord, stating that we have tried to serve the copy on 27/3/2025, wherein respondent counsel refused to take the copy, and the same is recorded in the order sheet of the trial court, my lord. So service may be held.
However, it is not there. We'll see.
Please, my lord.
Yes, 35.
Cell number 30, 34 dispose, 35 SP total.
Appearing for respondent. My lord, 5,000 is the maintenance order to minor daughter. The petitioner has not paid any single pie so far.
Has he served the copy on you?
No, he has not served. We have some amendment application he has filed. My lord, even on main petition itself, madam, 5,000.
Representation on behalf of the petitioner, and this is matter for discussion tomorrow. Next.
Cell number 36,
My lord, I appear for the petitioner in this matter, my lord.
Ramesh
My
K.R.
request this matter to be taken up next week, my lord. The reason is this, my lord, I'm told there is likelihood of settlement between husband and wife. Not
This is matter finally on 6th of August.
much. Interim order may kindly be.
Interim order earlier granted is extended.
37,
Much.
cell number 37,
Appear for the petitioner, my lord.
Look at this side. I will not be able to see the advocates. Yes.
37,
Appear for the petitioner, my lord. There was an objection, office objection regarding the maintainability of the writ petition.
You have realized it so early. 2023 objection.
Yes, my lords.
And why should we give you the liberty to convert it?
My lords, the petitioner is an
objection is
army
raised-
person, my lords.
So what? He has to be more, if he's more disciplined.
I'm not able to make contact with him, my lords. Hence, I'm filing memo of
It's not
withdrawal,
for
my
him.
lords.
No, what is that memo?
I'm seeking liberty to file an appeal, my lords. I'm
That's
filing
what I'm
this.
saying. Why should we give it? Who will answer to this delay from 2023 to 2025? When the officers raise objection, you should have acted upon it. And I'll say whatever it is, subject to the law of limitation, I will say. I'll not, whatever that is the matter is pending, it will not be counted.
Exemption may be-
We can't give because it's 2 years, 3 years.
I
time.
understand, my lords.
When did you file this? On 27/4/2023.
Yes.
2 complete years, 2.5, almost 2 years, 3 months.
I understand.
Then that you have to explain the delay. I will allow you for on that.
Filing
but,
and-
the delay has to be answered there.
Great.
The
Memo.
officers raised an objection with regard to the maintainability as the present writ petition is filed against an order passed in criminal miscellaneous number 127 of 2025 dated 3rd March 2023, which is a final order, and against that only the RPFC is maintainable. The counsel for the petitioner submits that the liberty may be granted to convert this petition into a RPFC. When an objection is raised in the year 2023, at this point of time, just like that the court cannot give the liberty by condoning this delay. Hence, the court is granting the liberty to the petitioner, and it is for the petitioner to explain the delay of these, the delay from 27/4/2023 till today, and it is also subject to the law of limitation. Yes, accordingly for statistical purposes, the petition is disposed of. Yes.
38, Adisha AS.
Yes.
Appeal for the petitioner, my lord. My lord, the respondent is.
Yes.
Appeal for the petitioner, my lord. My lord, the respondent is not taking the memo, summons, my lord. We have served through hand also and through RPAD also.
Who
we have
told you
served.
to serve the summons on the party?
We took the order, my lord.
Huh?
We took the order from the Honorable High Court
Last
earlier.
occasion I said serve it on the council.
No, my earlier we took, my lord, they didn't receive the summons. Afterwards, we took the order like serving through RPAD, my lord.
I'm passing an order, serve it on the council. Council will take. Then council, the petition is permitted to take out hand summons on the council appearing for the respondent before the trial court and shall file a memo to that effect by 12th. Default order.
There is also on the hand summons also issued, my lordships, but he is denied to receive the hand summons
When is the matter listed before the court?
on 1923, my lordships.
Huh?
1923.
After that, it is not
No,
listed.
it's not.
Stay is there here.
No stay, my lord. She is staying in the very same address, my lordships, but though she is denied to receive the hand summons.
It is the hand summons on the respondent. I'm saying hand summons on the council.
But this is disposal matter, my lordships.
Huh?
On disposal
The
matters,
writ petition.
they are not represented here.
What is writ order? Disposal against which order you are before this court?
Against, we have filed an application to release the amount in favor of the petitioner. That has been dismissed. And in the disposal matter, we have filed application, my lordships.
Hmm.
That the petitioner has been appointed as a guardian and dispose the matter.
What is to be done now?
Now,
File an application for substituted service.
please, that's what
Something has to be done.
I'm returning the hand.
Look at that. The
I'm
council-
returning the hand summons, my lordships.
The council has refused to take the summons. Party also refused.
Please, ma'am.
Party council refused to take the hand summons. She is residing in the very same address,
Yes.
but the postal shara shows insufficient address. Yes, no, as it is before the trial court. The petitioner submits that he'll come up with an application for substituted service. The list is matter on 5th of August. By the time application for substituted service of notice on so and so shall be filed, or else default order. Yes, next.
Serial number 40.
Return the action.
The petition has also placed the hand summons that are returned. Yes, next.
Serial number 40. Prasanna DP.
For the petition, my lord. We will take a process in the next
Each
date.
time default order,
Interim order may kindly extend, my lord.
interim order earlier granted is extended to the next. The name of the party. This is matter on 29.
Interim order may kindly be extended.
Interim order is extended till then. Next 42.
42. CM Nagbhushan.
Who is R2 and R3? Minor children.
No, ma'am, they are not minors, ma'am. They are major, my lords. I will take out the steps, my lords, in 2 days, my lords. What?
2 days time is granted for taking steps to R2 and R3. Default order.
Interim order, my kindly.
Interim order is extended till then.
43. Madhu MT.
No representation for dismissal tomorrow.
Serial number 44.
My lord.
For the petitioner, my lord.
Have you received the copy?
My lord, we already given NOC and entire file to the respondent, and today morning we came to know that she will arrange the same advocate again. So
she will
arrange the same advocate, my senior again. So kindly grant a week of time.
No, again she is engaging you. So come by 30th. The
Interim
request
order
of
can be
counsel for
extended.
the respondent, this is matter on 30th. Interim order earlier granted is extended till then. Next 45.
Serial number 45. KR Lingraj. Mahesh Ammar.
Respondent.
Then what hand summons, then both of are appearing.
I am appearing for
Respondent is
respondent.
appearing. Because respondent is already there, the respondent is already appearing, as there is no necessity for taking of hand summons. No representation for the petitioner. This is matter for dismissal on 7th of August.
Serial number 46.
Who is R2?
R2 is a,
Mano.
according to them, he is a paramar. According to them, he is a paramar.
Needful has been done.
Needful is done. Then counsel submits that the needful is done. Let's after service.
Petitioner used the wife as a court, and he has enriched himself and made the allegation against the wife, stating that he is in adultery, she is in living adultery.
Yes.
47.
Post after service.
Interim order may be extended.
Interim order earlier granted is extended.
But kind of honor, the order may be, she is suffering from of it, they are dragging it. Yes, ma'am.
Yes.
Yes, ma'am.
For a maintenance matter, how is a paramount necessary party for deciding the adultery and all? He is a party. Why is for maintenance? Why notices to him is necessary? Where is your senior?
We'll get the instructions.
This is
Kindly,
matter
Your
on
Honor, I will
Monday.
oppose Your Honor, kindly. She is suffering from without food. Whatever maintenance granted, meager maintenance, that has been stayed.
Understand, court has to balance the interest
Yes,
of all
yes,
the parties.
Yes,
This
sir.
is the matter on Monday. No further adjournment will be granted. Petitioner has to argue on the merits of the matter. List on Monday.
47.
Mature.
Rahmatullah Kotwal.
Petitioner in this case, my lord. Petitioner has rendered infructuous, my lords.
It is submitted, the petition has become, and counsel submits that the petition has become infructuous. Dismissed as infructuous. Yes,
Serial number
48.
48.
Great.
Shivaram SC.
What is this memo for dismissal of WP? A memo is filed stating that during the pendency of this proceedings, the matter was referred to the mediation, that is MC number 6528 of 2021. And as per the mediation report dated 16/5/2024, the parties have amicably settled the disputes. Hence, this petition has become infructuous, and the petitioner wants to withdraw. Accordingly, dismissed as withdrawn.
Serial number 49. Vide Gowda.
Settlement between the parties, Your Lordship.
Respondent, Your Lordship.
Next week, date may fix. Your Lordship.
It is settled already.
Yes, Your Lordship.
Then why next week?
I will file memo regarding.
I'll record that. It is submitted by the land counsel petitioner that the parties have entered into a settlement. And in that regard, he would file an petition to withdraw, considering the fact that already the parties have settled. The petition is dismissed as infructuous. If anything survives, the petition is at liberty of the party. List the matter on 29.
Serial number 51.
51 also same order.
Cell number 52.
Petitioner. Petitioner, my lords, first wife seeking direction for expeditious disposal of the execution petition. Second wife is the first respondent, my lord, who is served. So, first respondent is the mother of deceased expeditious disposal of the AIDS. It's in the family court at my lords, at Annex area, page 10 is the order sheet, my lords. Deceased husband, my petitioner is the first wife. Yeah, matrimonial dispute, my lord, that was compromised agreeing to pay such. Please. Please.
Lord, may I? I'm sorry, my lord, I appear for the respondent. There's already an order, my lord, that inquiry must be conducted at page number 35 by this honorable court.
Page number?
35, my lord. My lord, I am for the LRs of the husband. The husband has passed away. Now the execution is against the second wife and the mother-in-law of the petitioner, who is now aged 90 years.
It is an expeditious hearing, that's it.
Very well, my lord. There's an order, my lord, an inquiry must be conducted in the execution because I have discharged.
Let that order go, let that be done, we'll fix the time frame. Because
Very
it
well.
should have something.
Inquiry, they're now objecting for inquiry, my lord. Inquiry has to take place. I have discharged my burden. I have paid up 2/3 of the.
No, it's a responsibility of the court to take care of it in the light of the orders passed by this court.
Very
Now,
well.
what they pay is, it has to be expeditiously disposed of. That is, part of inquiry has to be concluded. Along with that, everything has to be done.
Very well.
The present petition is filed, seeking the following prayer. Land counsel for the petitioner submits that there may be a direction to the court to expeditiously dispose of the pending execution petition. Land counsel appearing for the respondent submits that already in WP number
49743.
743 of 2009-17 to conduct an inquiry. No, to consider the execution petition by giving reasonable opportunity to the parties and with the liberty to place the necessary material on record. Land counsel submits it is submitted by the land counsel respondent. They are not cooperating with the inquiry. Next paragraph. Having heard the counsels on either side for submission on record. The only relief that he is seeking is to expeditiously dispose of the pending execution. Already, this order is passed in WP 49743 in the year 2021. In that view of the matter, this court deems it appropriate to direct the court to dispose of this execution within a period of 3 months from the date of receipt of the court. Not 3 months, we are in July, by December.
Inquiry, my lord, because otherwise the other side is objecting to the inquiry being conducted, my lord. And my only request is that inquiry has to be conducted.
Inquiry, my lords, I am not having fully instruction on the inquiries, but my lord, they have.
No, this court is not saying anything. Whatever, if the other court has asked for, directed for an inquiry, that has to be done.
Very well.
Because I'm not saying don't stop.
Yes,
Yes.
Obliged.
Cell number 53. Rodu Mariappa.
Petitioner in this case, Your Lordship, I'll file a memo of retirement in this case, Your Lordship. He is not cooperating to dispose of the case. There was an interim order against the in favor of petitioner to pay certain amount. He has not paid any amount, Your Lordship.
That I will record. And we will first vacate the interim order.
Yes, Your Lordship.
This court, by order dated 23/5/2024, has passed an interim order. So far, the said interim order is not complied with. He has also not complied with the office objection. Land counsel the petitioner submits that he is trying to contact the party is not cooperating, and the party is not complying with the order passed by the
Chandrasekhar K.A.
For respondent, Milords, in the last date of hearing, Milords, direction has been given to them to file a memo of calculation.
filing a
Till
memo
date,
of
they not did the same.
We'll serve a copy on you. A petitioner is he sells vegetables, my lords.
Land counsel
As
for
a
the
Milords, I have to
petitioner,
check with the party, Milords.
Land counsel for the petitioner has filed a calculation memo, and the same is served on the counsel for the respondent. The respondent wants to get instructions in this regard. When do you want?
They're not paid any due of amount after the 2015 January.
There are two issues.
We are
If you
filing
don't
a
want
memo.
to look at the calculation memo, we'll hear the matter on the merits of it. If you want to look at the calculation memo and get instructions of your client, we
Yes,
will
ma'am.
adjourn the matter. Yeah, when do you want?
Wednesday.
Wednesday. Yes, there's a matter on Wednesday. Yes, interim order earlier granted, look at it in all these matters. Wherever there is an interim order, whether they ask or not, if it is represented, extend it till the next day.
There is a
Yes.
conditional order in this, my lord, because when they not, they are not capable to carry out the same thing,
We have filed a memo of calculation. You can go through.
they are not complying the order, my lord. So there is a conditional order. my
Here,
lord.
it's 1,40,000.
It's only till Wednesday. If matter will come, what is the urgency? We'll hear it on the day.
There are two kids.
Yes, next matter.
Care of the two kids.
Next matter.
56, Uni Reddy MN for petitioner,
Let's just matter after the report is received.
for petitioner.
Let's just matter after the report is received from the KMC. Yes.
Till number 57, Rupesh B,
Appear for petitioner Millard.
Bhargav D, but
Non-filing of acknowledgement for having deposited an
I
amount
will
of-
get order sheet, Millard. I have paid. Everything is paid, Millard.
Where is the respondent? Counselor, the petition is present and it is submitted that he has already complied with the order and deposited an amount of rupees 72,000. No representation for the respondent. Let's this matter on 31st.
Right.
till number 58,
Appearing for petition.
BB Sidramaya,
Pray for 2 days accommodation. May kindly be called on.
copy served. Not
On IA number 1 of 25. Filed by whom? 1 of 25 is filed by whom?
That is by petitioner.
But
Filed by you.
consumer record held up in other court, maybe next week. Take.
Office objection shall be complied with within 3 days default order.
Till
Yes,
number
ma'am.
60,
My lord, interim order, ma'am.
Interim order earlier granted is extended.
60,
Give that memo of withdrawal is there. Memo is filed seeking to withdraw the petition. The same is taken on record. Dismissed as withdrawn. Next 61.
till number 61. 61, Prakasham Patil,
No representation for the respondent.
petitioner.
List this matter on 4th of August. By the time if the office objections on the said IA are not complied with, the IA shall not be taken on record. That objection shall not be taken on record.
62,
Returned unclaimed letters.
Notice to respondent returned unclaimed memos redeemed service of notice. Print the name of the party. List the matter on 31st
Interim order.
notice. Print the name of the party. List the matter on 31st.
Interim order.
Interim order earlier granted is extended till then.
till number 63, C. Shankar Reddy,
My lord, appearing for appellant, we have served the process also. We grant 1 week time. We are given hand summons to a party, my lord, to serve the.
The petition submits that he has paid the process. History is directed to send the notice. The petitioner submits that he has already he is going to serve the hand summons and file a memo. List the matter on 12. Yes, miss.
till number 64,
Already respondent
Someone
is
has filed
served on 20th of August. Interim order earlier granted is extended till then.
till number 65, party in person, Madhvi,
Objections to be complied with within a week. Default order.
till number 66,
Ladyship, in this case, we've served the hand summons. They've not turned up, Ladyship. Now, the proof of service of hand summons is there. We've served them on, and then only we mentioned yesterday.
Who is that? Okay.
Philomena Ross.
We'll print her name and we have to take it tomorrow. Give the then counsel to the petitioner. As filed before this court the memo to show that a memo stating that the notice is the counsel appearing to the respondent before the trial. Where do you get the name of the advocate?
It's there in the hand summons. There's Philomena Ross mentioned there. His signature, and she is appearing in all the matters in the trial court.
When the memo is filed, memo should contain, because from signature, court cannot write on a
We'll
paper.
just write it down, Your Worship.
So and so, print the name of the counsel and notice to respondent is insufficient.
And Your Worship, can it be taken on Monday?
Monday.
And Your Worship, the two matters connected in cause list 2, number 3 and 6. Can that also be put on?
Cause list number 2, 3 and 6, post along with.
Hand summons has been given in one of those matters.
In this also hand summons you have.
Yes. Even I've served the.
Same in 3 and 6 also, you please.
Only in
verify.
3, not 3, not in 6. Only in 3. 6.
3 has taken. Print the name of the counsel. And what about 6?
6 is a fresh matter, leadership. It's
Yes, 6 list on Monday.
this
Yes.
month. I'm so grateful.
Chair number 67, Ajit PB.
Notice. How much is the amount? In MC, she's receiving 7,000. When is this filed? Criminal miscellaneous. And MC? Did the court consider this aspect? It was not brought. Have you not brought to the notice? Please come. Let counsel the petitioner submits that. The wife is receiving an amount of rupees 7,000 as maintenance in the MC by order dated 17/11/2023. Now this in the criminal miscellaneous, court had granted 3,000 as maintenance by way of impugned order. It is submitted that the husband's salary admittedly is 20,000 and half of his salary is paid for maintenance. Considering the same, there shall be stay of all further proceedings. Question 2, so and so, so and so. Notice.
Chair number 68, Shubha S.
I represent the respondent.
Manjunath B.
Represent the respondent.
Manjunath BR.
Reason being, the visitation is continuously being exercised every Saturday from 10:30 to 1:30. So we will
But
find
they have the interim order for the last 2 years, my lord. Only 3 hours of visitation is being given. But family court,
What was the order?
please, my lord, the overnight stay was granted.
So from how long this is going on? From 2020?
23, my lord. Only 3 hours of visitation is being
Why
given.
should it continue for only 3 hours when it is going well? Why should it be 3 hours? Why not he have more time?
But he is for to the petitioner hearing that has been not recorded in the order sheet.
Submitted that on the last occasion, an amount of rupees 3 lakh,
5,100
5,100 by way of a DD is paid to the
petitioner.
the
Petitioner.
petitioner, and the same is not disputed by the learned counsel for the petitioner. This is not on Monday, we'll have it on Wednesday.
Please.
No, he is only saying about what is given.
Please.
Yes, yes,
Chair
yes,
number
yes.
69,
Next.
69, Ravindranath K. Whether
Learned counsel for the petitioner is present, no representation for the respondent. List this matter on 6th of August, interim order earlier granted is extended till then.
Cell number 70, adjourned, 71. Cell number 71,
Respondent. There is
Anmaira.
a counsel for the petition, no representation. List the matter for dismissal on 29th. Counsel for the respondent is present.
Cell number 72, Madhukar M. Deshpande, for petitioner.
What is happening to the respondents? And counsel the petition is present. He submits that the interim order is being complied with. No representation for the respondent. This is matter in the month of October 14. The interim order that is granted by this court is extended until further orders.
Cell number 73,
Respondent, please.
Bhargav. G.
Millers. The impugned order, please, Millers. It is a common order passed on.
Faster.
Cell number 74, Ravindranath K.
And so that the matter was adjourned for 1 week. my
Only
lords.
in respect of the, she is earning, the intimation has been, I have received recently, Your Honor. For that, I have already given the certificate of TDS along with my application.
Which order has to be modified? IA 1025 for modification of the order. Which order?
I will withdraw this one. And I file the memo in respect of the.
I number 1025 is file seeking modification of the impugned order. That anyhow would be done finally if it is required.
Please.
Done, and such an application is not maintainable. Accordingly, I number 1025 is dismissed. Now on the merits of the matter. Argue on the merits of the matter.
Please, Your Honor.
What is the impugned order?
Impugned order is 10,000 rupees awarded in respect of the
10,000 to
wife.
the, where is
Wife,
the
only
page
wife.
number?
The page number.
Sir, Arish Kumar, sir, from your office, there is lot of disturbances to the court proceedings. Please, sir, mute.
Yes. Page number? Come to 61. 10,000 from the date of
10,000 is
application,
awarded
so
for
and
the
so.
petitioner.
In 3 months. What is your income?
My income is 50,000 rupees.
50.
50. And in the presently, I came to know that rupees
50.
50. And in the presently, I came to know that she is working from January 2024.
January?
2024.
How do you come to know?
At the time of we have together at the time of petitioner and respondent.
What is date of order?
22/12/2023.
23. December 23.
So now, before going to that, please tell the court on the merits of this matter.
Please, Your Honor.
So as on the day you're earning 50,000, court has granted 10,000. There cannot be any difficulty.
No, Your Worship.
for you to
The
pay.
two age-old parents are with me, Your Worship. I have to take care of that.
So
them.
10,000 for you,
And
10,000
30,000
10,000 for your both the parents. What job now according to you? What do you say about her
My
present
lords,
occupation?
order passed on 22/12/2023. His income is above 70,000. My lords, I made a memo on that, my lords, 20/3/2024. This honorable court passed an order, my lords, to income of the petitioner on that day because he was getting the 70,000 of salary. And also direct to the.
For salary.
My lords, I joined that job under 3 months work, my lords. 2.5 months salary received per month 15,000 salary. She left the job because, my lords, that 45 kilometers of distance to the office to home, my lord. That is the distance. She was joined the Devanalli on the company for 15,000. So she left the job, my lord. So she don't have any job, my lord. She is not going. How the documents are furnished by the petitioner, I don't know, my lords. He is working as a chartered accountant officer, chartered accountant under my lords, and he
Now,
admits.
when this is filed in the year 2024. This is on 17/1/2024. For how long you worked?
2.5 months, my lords.
From when to when?
I filed in the last date of hearing, my lords. I filed my statement.
In which case you have filed? In your case?
And the
Or in-
74.1, that's my case, my lords. I filed a memo in which June 2024 to August 2024, my lords.
Then again, after that, you are not working.
Please, my lords. Even, my lords, they are avoiding to.
What about your salary? Is it 50,000 or
50,000, Your Worship.
70,000?
Because the earlier when I joined that particular job, the additional work has been given. For that period only, I have got 20,000 rupees additional salary.
What is that period?
I have filed an affidavit dated 15 April 2025.
In which case you filed, your case or their?
First
My
case,
case,
my lords.
3460.
Please, my lords.
You have a copy of it, I do not find it.
This affidavit filed, my lords, as per the instruction and order of this honorable court, my lords, 20th-3/2024. Direct him to produce the salary certificate and
Anita?
surname, memo, date and affidavit date.
Affidavit dated 15/4/25. 15/4/25. And also one objection dated 11/3/24 also it is there.
Please, 11.
11/3/24 on the objection ಹಾಕಿದ್ವಿ ಮೇಡಮ್ ಅದು 11/3/24. 11/3/24.
11/3/25. Statement of objection.
ಹಾ
5/3. 11/3. 11/3 statement ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ ಕನ್ಫ್ಯೂಷನ್ ನಾನು.
The page number 5 you are on. The page number 5 you are on. That is page number 5 your worship. In that is specifically mentioned is the order of the appointment order. The
What
second
is there? I don't find any memo in this. Affidavit is not here.
affidavit is also filed on 24 your worship. 15/4/24 it has been filed. 15/4/25 I have filed the affidavit your worship. But the document is in annexure H your worship. Center Private Limited, for which you are entitled for 20,000 rupees along with the fixed salary of 50,000. 50,000 till the work is completed current financial year.
No, you're saying that I state that the transaction reflect in my account dated so and so, so and so. What are those amounts?
Those are the amount earlier to I joined this particular service your worship.
No, what is that amount? What is that amount transferred from your account to your mother's account?
Yes, mother's account. I filed the affidavit in respect of that. I have mentioned the date also your worship. At the time of marriage I have that transaction has been happened, not after the marriage. It's prior to the marriage your worship. Those documents I have furnished before the trial court along with my assets and liability your worship. On that only they have come forth with before this honorable court your worship.
Yes. So according to him, it is only 50,000.
My lords.
According to him, it is only 50,000.
50,000, I left the job, my lords. Now, my lords, this honorable court directed, order dated 20th-3/2024, directed him produce the account details and the salary details of the petitioner. He filed one affidavit and stating that, my lords, earlier transaction, what is the present income of the kindly,
Not filed a statement of assets.
please, my lords, and no, he filed assets and liability.
Anything more now?
No, this honorable court directed to him, my lords, is that date, my lords.
As per the judgment of Rajesh and Neha, whatever is required, has he filed or not?
Please, my lords.
Why should we go into other things now?
Please, my lords.
So as per that, according to him, his salary is 50,000, and sometimes for 1 or 2 months it is 70,000. So how do you deny this fact that it is every time his salary is 7,000?
I'm not denying, my lords. He is not complying the order possible trial court from last 24 months, my lords. That is the difficulty.
What is the order of paying 10,000?
No interim order. There is no interim order from here.
Why you are not complying with that? And why should we hear this?
No, December it has been the order has been
Either
passed.
you should have an order from this court, or you should be complying with the order of the trial court, family court. You are not doing, when you do not have respect for
Lordship,
the court order.
so one
Why should
submission.
the court hear?
One
this?
submission. December order has been passed. She started the working from the January 2024 itself.
No, my lord. June, my lords. I filed a clear memo.
So both of you will take decisions on your own. Court orders has no sanctity. So why are we wasting time on your client who has no respect for the court orders? So I will not hear your petition. I'll hear his petition. Please tell the court how are you entitled for enhancement.
My lords, if Honorable Court, my lords, person at 10,000, he admitted his salary on that of time, my lords, 70,000. My lords, he stated that, my lords, he had loans, my lords. He never stated and produced the document he had availed the loan from anybody. And his IT returns, my lords, in that loan column, he has not availed any loan. He produced these as IT returns acknowledgement before the trial court. In that statement, my lord, there is no loan transaction. That was the zero. There is no loan and any liability for that purpose, my lords. For that reason, my lords, and I am seeking a 20,000 of the maintenance to the petitioners, my lords. That is the petition of 70.
Lordship, she is a graduation of BA Psychology, and she is a capacity to work, Your Lordship. And I am getting the 30,000 rupees is directly deducting from my salary only. I have produced that assets and liability in respect of that. And my two parents are with me only. I am only son. I have to take care of them also. The father is bedridden because of the age old and some spinal cord problem.
What about you?
All those documents.
Forever you will not work. Not that you are not get an employment. When you are able to get, just because it is far off, you will resign and sit at home.
No, my lords, that is the difficulty to, because, my lords, the mother of the that respondent, my lords, is ill health, my lords. She is residing in that parental house. That is the difficulty, my lords, and that inconvenience, my lords, for that traveling.
Like after 6 months, you should.
To take care of them, son is also there.
It will be reviewed after 6 months. You'll have before the trial court. You place all that. What is that? What are the efforts that you have made to get a job? Please come. Agreed with the orders passed in criminal miscellaneous number 314 or 306 of 2023, dated 22/12/2023, whereby the court has granted 10,000 per month as maintenance. Both the wife and the husband are before this court. The wife's petition is WP 10584 of 2024, and the husband's petition is WP 3460 of 2024. The wife has filed this petition seeking maintenance of how much you sought for?
Lords, I sought for
25,000. 25,000.
Has filed the
Sought for
petition seeking
25,000.
maintenance of an amount of rupees 50,000 per month. According to the petitioner, according to the wife, the husband is earning, parties are referred to as wife and husband. According to the wife, the husband is earning 1,50,000. The husband has filed a statement of assets and liabilities, wherein it is stated that his salary is 50,000, but on some months where he has been given extra work, there an amount of rupees 70,000. In the year 2024, she got a job and earning. Then counsel for the respondent submits, counsel for the wife submits that she worked from June to August 2024, and she was getting a salary of 15,000. But the place of work is far away from the house, and it's difficult for the wife to travel all the way. She could not continue the job, and now she is not working. According to the counsel for the respondent, the salary is 70,000 per month, as per the statement. The court, by order impugned, had granted 10,000, while granting the same. That the wife is capable and qualified she should not remain idle without getting the job. The court has also, considering the fact that some amounts are deducted towards the loan, has observed that the husband has a responsibility to take care of the needs of the wife and accordingly granted the amount. This petition is filed on 17/1/2024. There is no stay granted by this court, and the petitioner has not paid any amount to the wife till now. On a query from the court, and counsel, the petitioner submits that as the wife is working, that is why he is not paying the money. He has not even filed any application for stay. He has not brought anything to the notice of the court, but he is not paying the amount. Next paragraph. When an order is passed by the court, the parties have to comply with the said order, paying the amount. When he has no respect to the orders of the court, there is no point in this court considering his application, questioning the impugned order. In that view of the matter, this court is not inclined to go into any of the submissions that are made by the learned counsel for the petitioner, husband, not petitioner, husband. And accordingly, WP number 3460 of 2024 is dismissed.
And with liberty to file modification application before the trial court. Your worship.
Why should we?
Because
That I will record in this order. Next, WP number, then coming to WP number 10584 of 2024 is concerned. The wife, according to her, she has worked for 2 months, that is the 3 months, that is between June 24 to August 2024. For that period, she is not entitled for maintenance. For the remaining period, as ordered by the court, the wife, not that, the husband's income is 50,000 per month. According to him, he has to support his parents and has to take care of the other necessities. In between, whenever there is work, he is getting the additional amounts. Considering the salary of 50,000, this court is inclined to grant an amount of rupees 15,000 as maintenance to the.
And the 30,000 is a.
But not all these EMIs as stated by the petitioner. Considering that he has to take care of his parents and also the wife, this court is inclined to enhance the amount from 10,000 to 15,000. The wife, then coming to the qualification of the wife is qualified and she is capable of earning. Nothing is forthcoming. The wife, when capable of earning, cannot sit at home and cannot depend upon the husband for maintenance. After 6 months, the husband is at liberty to file an application and to review this order, that file an application on that day, and by that time the wife shall place before the court what are all the efforts that are made by her to secure a job. Basing on the same, the court is at liberty to pass appropriate orders accordingly disposed of.
Bill number 75, Viren Michael Press, for petitioner Adina Chakraborty.
For the petitioner, this matter.
What is this recalling the order dated 2/8/24?
That on the last date was already, my lord had already recalled that.
Why again they're like, they don't look at it? I think they stopped reading the orders. What is 2 of 24?
My lord had dictated the order. It was, my lord had passed an interim order at the time of granting stay that my IA for visitation rights was stayed rather than the GNWC proceedings. So I'd filed the IA to recall that order. My lord, on the last date, had recalled that order.
IA number 1 of 24 is dismissed as not pressed.
Although that was for stay of the entire GNWC proceedings. I am not.
Accordingly, this IA number 2 is also
Yes.
disposed of.
Yes. So now it's for hearing on the main on merits.
This correction to be made here, not pressed accordingly. IA number.
Is at page 27. I'm appearing for the father.
27.
27. With regard to interim visitation rights.
What was the order?
The IA number 6 is allowed in part. The applicant respondent is permitted to talk to the minor child through video call / audio call on every Tuesday and Wednesday between 7:30 p.m. to 8 p.m. And he is also entitled for visitation rights to meet the child on every second Sunday from 11 a.m. to 5 p.m. in any common meeting place like the mall or restaurant at the convenience of the minor child at Bengaluru. Respondent is permitted to take part in the school activities of minor child with prior intimation to the petitioner on bearing the responsibility of education expenses by paying the school fees for the academic year 2023-2024 and till
What is the age of the children?
now she only one child.
She is here, Your Lordship. She has come.
Now, my lord, this has been an interstate exercise with regard to where is the child and where is the wife as on date. Right from Gujarat to Karnataka to Tripura to Rajasthan, 4 states, I will bring to the notice of this honorable court of how she is avoiding court orders. First time I'm seeing my child after 1.5 years. First time. She had appeared only once during in the family court. And before that, for 5 years, I have not seen my child since 2020. In the past 5 years, I've seen my child only for
This order passed.
10/11/2023 is the order passed for visitation rights.
11.
2023.
Visitation happened after this order?
Only once in the.
Your Lordship, I have requested the petitioner to, through video call, I have requested to talk to the child. But the child is not, not willing to talk to the father. So in the between, I am in trouble, Your Lordship. The daughter is here only. Your Lordship may examine the daughter. If I am not having any objection.
Where were you from 2023?
I was there in Bangalore.
If that is the case, that the girl is not passed giving these visitation rights, you are still aggrieved by such order. Are you not supposed to come before the court? Are you not tell the court what is your difficulty, or you will just keep quiet and you will violate the orders of the court?
Your Lordship, in the meantime, they went to Supreme Court also.
What happened in Supreme Court?
The Supreme Court, they have ultimately withdrawn the cases.
When did you file and when did you? No, as long as the Supreme Court stays the order of this court or the family
There was
court,
mediation also held in Supreme Court. There the mediator told to talk to the child, the daughter. The daughter audio recording is there where she is crying and telling, I am not interested to talk to you. You have done wrong to my mother.
So
I am not, and you have told false thing to me also. I am not. You just solve the issues between yourself.
What is her age?
13, Your Lordship.
So now she is 13. When the order is passed, it is in the year
November 23.
11.
November
23.
November 23. She's almost 11 years old then. 11 years old girl says that you have done something to my mother, so I will not talk.
Because she has seen in front of her eyes the father is beating the mother. So all these things she has witnessed from the very childhood. So that has impacted her very badly. That is why maybe Your Lordship, because I am ready to oblige the order of the court. But if the daughter is willing, daughter is here only. Your Lordship may examine the daughter. She is here. If she is willing, I can bring any point. Now the mother is staying. Daughter, she is here. If she is willing, I can bring any point. Now the mother is staying in Rajasthan in the house of the father only, because there is no support from the father, the petitioner herein, financial or anything. So the respondent is at the mercy of the father. So I am ready for obliging the order of this honorable court.
Who will oblige staying at Rajasthan?
He is staying in Gujarat, Your Lordship. Sure. The petition is.
What is the petition doing in
I will
Bangalore?
explain. I will explain the situation exactly what has happened, my lord. In the year 2020, in the beginning, both the petitioners were living in Gujarat. In 2002, and she's filed an MC case for divorce. From 2020 till
Is in Bangalore.
she moved to Bangalore with a child without intimating me from Gujarat. While the child,
What was she doing in Bangalore that time?
Your Lordship, I'm just, in 2020, the GNWC case was filed. In
What was she doing here?
She was working in a parlor, Your Lordship, earning 18,000 per month because she is not that much educated to survive by herself. So she has come.
She come to Bangalore.
She was working here in some of the salon or something. She was.
No, she's from Gujarat.
The petitioner and respondent initially, after marriage, was staying here in Bangalore. Thereafter, they have gone to Gujarat. Thereafter, again, they have come to Bangalore. Thereafter, when 2020, this GNWC was filed, MC case for divorce was filed, he was not responding. In 2022, maintenance case was filed. Criminal, when CMIS was filed, then he has appeared and has recalled the application for this GNWC and MC. Now he is contesting. When the question of maintenance has come, earlier he was quiet. He was not interested for MC also and GNWC also.
How much was the maintenance awarded?
Maintenance has not been awarded yet, Your Lordship, because it is still pending. There was change of advocates also, and there was some miscommunication. Now the maintenance case is on 5th of August.
my lord, I have to bring the true.
August.
My lord, I have to bring the true nature of facts. This is a completely wrong submission. Both of us were living in Gujarat while the child was studying in the school, having an extramarital affair, living in Bangalore along with a minor child with another man. There is enough sufficient proof that is before the trial court. I have applied for visitation rights. I have obtained the visitation rights on November 2023. She does not comply with visitation rights in November. She does not comply with the visitation right in December. I filed a memo before the trial court, direct her to be present along with the minor child before the court. In Jan, this is the first time we are seeing her since Feb 2024. In Feb 2024 till around June 2024, no idea for whereabouts. Advocates were taking time. They have changed their advocates multiple times. In June 2024, we were informed and we found out information that without intimating the trial court here in Bangalore, she has taken the minor child out of the jurisdiction of this court and run away to Tripura along with that person and with the minor child without informing the honorable court. I filed a memo before the honorable trial court. Direct, where is her whereabouts? Kindly give directions about her whereabouts. They have not responded to the same till date. I filed contempt before the honorable family court. That contempt petition, the honorable court has passed orders on that contempt petition to register the contempt against her for taking the
Your
child.
Lordship, tomorrow the contempt petition is there for filing the objection.
Yes, for taking the child without the permission of the honorable family court. Now that she has filed the 3 petitions before the family court in Bangalore, that is the GNWC 125 CRPC and the divorce case, since she was not getting favorable orders, she went to the Supreme Court and filed 3 transfer petitions to transfer all the cases from Bangalore to Tripura. All 3 cases have been dismissed by the Supreme Court. The contention that it has been withdrawn is false. On 5th of May 2025, all 3 of her cases have been dismissed. Now because the Supreme Court, after arguments, has realized that from Gujarat she has come to Bangalore. From Bangalore, visitation rights is passed in favor of the father. She has not complied with the visitation rights. To escape the visitation rights and violate the orders of the court, she has run away to Tripura. When her Supreme Court cases were dismissed, transferring the cases from Bangalore family court to Tripura, now she's run away to Rajasthan. Now this is the behavior of this respondent in this matter. Where am I to see my child? Which court am I to go to? I have got visitation rights in my favor. How am I to comply with the visitation rights? I've provided the screenshots of all the video calls that I'm trying to call my daughter. Not a single time has been picked up because she switched off the phone, the mother. Now the mother here has no regards for the orders of the court. From 2023, orders to avoid the memos, to avoid directions from the court, for her to be present.
I can produce the video, audio recording and the screenshot, this email communication also, that I have proposed to call him because some exams were going on. So I have asked you call this time.
There was a direction.
That email communication is there.
What happens to physically meeting the child?
I do not have any problem, Your Lordship. The mother does not have any problem.
What is it? First of all, no, it's not about the problem. Why did you leave the jurisdiction of the court without permission, having filed a petition here?
Because, Your Lordship,
Somebody, husband stays in Gujarat, you will file the petitions in Bangalore, orders will be passed. Now you will go to Rajasthan.
Your Lordship, the problem is he is not supporting financially.
No, you have come on your own to Bangalore from Gujarat.
He has done so much of cruelty. All the proofs we are having, he has made me to.
About that, you have come. You have only chosen to choose this forum as for filing the cases.
No, I was here for long. I have gone to Tripura for 6 months or 1 year. Now I am again in Rajasthan in my father's house only. So
you will be contesting the cases of Bangalore from Rajasthan. And the child interim order to comply with child will not be available in Bangalore. Why did you
if the order is in any public place, in any restaurant or any mall like that, let them go to Rajasthan and meet the child. I don't have any problem. I don't have any objection.
Then shall I pass an order that you should not leave the jurisdiction of the court? If this is a submission, that's not acceptable. What is that?
Because
you say you file a JNWC here and you say that go out to Rajasthan and exercise the visitation. What is the submission?
Your Lordship,
you have to advise her. If you submit like this, what is that she will understand?
Your Lordship, she has admitted the child in Rajasthan in school. Now if the...
No, that's not right. That's what I'm saying. You have to, why did you file the petition here? When the orders were passed, whatever you want to do, can you do? You cannot. You started here in Bangalore.
Because I was staying here, Your Lordship, that time.
I think at least you understand. If the client is not understanding, you are understanding what I'm saying. So that's not the way to answer to the court. 5 o'clock in the chambers.
Yes, much obliged.
5 p.m.
Ask them to come to the chambers at 5 o'clock.
5 p.m.
Obliged, Your Lordship.
Still number 76, Suya Gerele, for petitioner.
Your Lordship, interim order has been vacated in this matter. Request your Lordship to take it up next week. Please.
My Lord, Daye may be disposed of.
Yes, we'll hear the matter. What is the order? Where is the impugned order? Get your file. You have the file.
Yes.
Open the file. We'll read the order. Page number. Order is at page 9.
Yes, sir.
Come to the order.
The learned counsel for the respondent applicant has filed this IA number 3 under section 24 of Marriage Act.
Interim maintenance amount of rupees 10,000 is granted.
Yes, your Lordship.
So now we'll go to the order reasoning part where the court had discussed. So please come to page number 17, internal page of 9 of the order. Above paragraph number 9, the respondent is very cruel in her attitude and nature. Petitioner is an employee at real estate office. You saw that?
Yes, your Lordship.
Read it.
The matter. If it may
Yes,
be
your
passed
Lordship.
over.
After lunch.
Much obliged.
This next.
Still number 77.
My Lord, serial number 77. May I request that the name of Mr. Joshua Samuel be removed from the list of the petitioner matters?
Arun Govindraj.
Rapia for the petitioner. The petition has become infructuous. Not the limited relief sought was that the injunction, ex parte injunction, was not granted by the family court. After appearing, the husband has given an undertaking that he will not interfere with the child's custody. Therefore, this petition has become infructuous.
Then counsel the petitioner submits that the order impugned is the injunction that is granted. And it is
The injunction was not granted. Ex parte injunction was not granted. That was challenged.
Granted by the court. And later, the husband has given an undertaking that he will not interfere.
Yes.
He will not interfere. Hence, as the relief that's already worked out, nothing remains for consideration. Accordingly, dismiss. delete the name of Mr. Joshua Hudson Samuel.
Obliged.
Yes.
Cell number 78, Lingaraj amendment, preliminary hearing.
I'm applying for a petition, my lord. Short date, my lord.
Who short dates?
Monday, my lord. Senior is held up in another court, my lord.
Pass over, ask him to come.
Here not. Andhra
Every
Pradesh.
matter can't be
No,
listed
Monday,
100
my-
times.
Monday, my lord.
List on Tuesday, no further adjournments. Preliminary hearing, no further adjournments. Preliminary hearing, 2024 matters, still you people are asking time.
Obliged.
What remains in the, what is there in?
The petitioner.
Ashok Kumar for respondent.
You have an interim order in your favor.
Yes, my lord.
No representation for the respondent. Counsel.
My lords, I am filed Okalat, my lords. I am representing the respondent, my lord. Respondent number 1, my lord.
Which matter?
79, my lords.
Yes,
My
to
lordship,
the papers.
if they are ready to come before the mediation center, my lordship. Because
Yes,
I'm
my
the
lords.
member of- Please.
I will advise that.
Please.
The parties are ready for the settlement. The party shall appear before them. Where are they staying?
My lord,
Where are they residing?
he's residing at Tumkur only. Both are.
Tumkur only, my lords.
Before the Bangalore Mediation Center. On which date?
Any con-
On 4th of August?
After the 10th, my lord.
After 10th.
10th.
4th on 11th of August?
Obliged.
Yes.
Obliged, my lords.
No, this is Bangalore only. Or Tumkur Mediation Center?
No, Bangalore mediation center.
Bangalore Mediation.
Please. Interim order may be extended.
Interim order earlier granted is extended.
Cell number 80,
Yes.
80,
Give those
Viresh
papers.
Shakya.
No representation for dismissal tomorrow.
Cell number 81, 81, DM
Petitioner, my
Mohan
lord.
Kumar.
Lords, you filed a IF seeking amendment in the petition that's not been taken up for consideration.
Writ petition of 24, amendment of prayer. What is amendment of prayer? Let's see.
Lords may kindly pass over, my lords. My senior is held up in the other court.
Just ask him to come. Pass over.
Cell number 82, Manjula D, Tashina JD for petitioner.
Paying for petitioner lordship, kindly pass over motion. Lordship, kindly pass over motion.
Cell number 83, 82, 82 pass over, 83.
Let counsel the petition substance of the petition has become infructuous, dismissed.
Cell number 84,
Petitioner, my lord, I'm only seeking direction to the trial court to dispose of the petition.
Which year is the?
My lord, 2020 was the divorce petition filed by the husband, my lord.
Which
Wife
court
also,
it is? Which court it is?
my lord, in the family court, Bangalore, my lord.
Bangalore, no 2020 matters direction.
My lord,
The petition is filed seeking the following relief.
It's in
2019 by December 15th. Thereafter, only they can take up the 2020 matters. Hence, at this stage, this court cannot grant any direction to the family.
However, to dispose of expeditiously without timely.
That kind of directions are neither here nor there. Yes. Dismissed. Next.
cell for admission, cell number 85, 85, KN Lingaraj.
But respondent is a landlord, is a more than dry land and wetland, is more and wetland.
Take that order.
That page 11.
So please come to the impugned order and start reading it.
This is a petition filed by the petitioner under section 127 of CRPC with prayer of enhance the monthly maintenance awarded to her by 3,000 to 15,000. The brief of the awardment to the petition are the follows. The petitioner is the wife of respondent and she had filed MC case 316/12 before this court for enhancement to maintenance from the 15,000 per month to rupees 10,000 per month, and the same was allowed by this court and the earlier maintenance was enhanced from the 15,000 per month to the rupees 3,000 per month since 2016 for prices of the essential commodity has been arise to it the hard of the land, her life of the in present maintenance of the 3,000 per month. She required the at least 15,000 per month to meet her delay needs. The respondent is having the irrigated to land of the growing the sugar cane, paddy, and she is also running the floor was refused by the respondent as she left with no option. The filed of petition seeking the announcement of the maintenance. At least 15,000 announcement ಮಾಡಿ madam.
Husband age 68 years. Wife age 62 years.
Smile.
Court has already considered and granted one more 1,000. What is his income?
4-wheel business ಮಾಡ್ತಾರೆ.
Retired employee. And you are getting pension.
No pension madam.
What were you doing?
Housewife madam.
2 children. They're all they're earning, and the property is also given to the children. You are with the children, and you want maintenance from him. 68 years old. Please come. The agreed with the order passed and criminal miscellaneous number 422 of 2018, dated 10th November 2021, whereby the court had enhanced maintenance from 3,000 to 4,000. The wife is before this court seeking enhancement of the maintenance. Earlier, the wife had filed a petition, that is criminal miscellaneous number 326 of 1995, seeking maintenance, where maintenance of an amount of rupees 300 per month was awarded. And again in the year 2000, she had filed a petition seeking enhancement. It is enhanced from 3,000 to 15,000 per month. Then in the year 2012, she has filed criminal miscellaneous number 316 of 2012, seeking enhancement of the maintenance to 15,000 per month. The court, by order impugned, had enhanced the maintenance to 4,000, and while passing the said order, the court had observed that considering the landed property of the husband, court had granted an amount of rupees, another enhanced an amount of rupees 1,000. Then counsel for the petition submits that the husband is having the landed property. Either before the court below or before this court, there is no evidence to show what is the income he is deriving from the property. The land which is in the name of the father, an extent of 8 acres is already given to the children, that is recorded in the order. The petitioner, the husband, as on today, is aged about 71 years. Considering all these aspects, this court do not find any reasons to enhance the amount, and accordingly, the petition is dismissed.
Bill number 86. 86. Then Dharmapal for petitioner.
I appear for the petitioners in this case, my lords.
Yes.
My lords, this is a case from this case, my lords.
Yes.
My lords, this is a case filed for enhancement of maintenance, my lords. So on 24/12/2021, the petitioner filed petition under section 125 of CRPC for claiming of maintenance from the respondent, my lords. On 30/7/2022, the learned second additional family court at Mysore passed judgment in criminal miscellaneous number 874 of 2021.
Granted 4,000 per month to petitioner number 1.
Yes, my lords.
And 3,000 each
To petition.
for the children.
Yes, my lords.
So 6 plus 4, 10.
10,000, my lords.
So what is the income of the husband?
My lords, the income of the husband is around, he's a government employee, my lords. He's getting a salary of 51,860, my lords, monthly. There is
Paragraph number 610.
10, my lords. Page number 14, my lords.
Yes.
Page number 14, paragraph 10, my lord. Since the respondent has not contested the present case, it is incumbent upon this court to accept the positive.
Contest the case.
Sorry, my lords.
You didn't contest the case.
My lords, I'm unaware of that, my lords, because senior is currently hospitalized. So he gave me instructions and he sent me, my lords. Upon this court to accept the positive testimony let in by the petitioners to prove their case. From the said unimpeached testimony, it is quite clear that the respondent, though having a gross salary of rupees 45,048 per month, has neglected and refused to maintain the petitioners who are unable to maintain themselves. Therefore, having regard to the admitted relationship between the parties, the age of the respondent, his income, and his liability to look after his aged and ailed mother, the lifestyle for which the parties are accustomed, and also the fact that the petitioners are presently residing under the mercy of the parents of the petitioner number 1 for their livelihood, I hold that it is just proper to direct the respondent to pay monthly maintenance to the tune of rupees 4,000 in favor of the petitioner number 1 and rupees 3,000 each in favor of minor petitioner 2 and 3, and also to bear the educational expenses of the minor petitioners and cost of this litigation. Hence, I answer this point under consideration accordingly.
We'll increase another 4,000.
Sorry, my lords.
We'll increase another 4,000.
My lords, it will be very difficult for the petitioners, my lords. They have school fees, their basic facilities also is not being met by this maintenance amount which is awarded.
30% of his salary.
Yes, my lords. Kindly a short date, my lords, so that my senior could appear if in front of you, my lords.
This is matter as part heard on Monday.
Much obliged, my lords.
Number 87.
Please, ma'am. Now, this matter is said to have been settled. A week time maybe can be granted, my lord.
It is submitted that the matter is settled between the parties, but however he submits the same like in the other order that he wants to file a.
Cell number 88.
Yes.
Petitioner. So notice had order. Notice was there.
Notice is there. It is served.
Sir, yes, my lord, the family court awarded maintenance of rupees 6,000 to the petitioner number to the respondent number 1, being the wife of the petitioner, and 4,000 to the petitioner number 2. My lord, the petitioner did not contest the matter before the family court. My lord, he stated that that he could not appear before the family court.
What to do? What to do now? Why should we interfere with that order? When an opportunity is given, you didn't choose it. And whatever the court has granted, that we can't interfere with that. It should be some
And
reason.
therefore, my lord, the family court came to the conclusion that the respondent could not did not contest the matter, and he neglected the wife and awarded them maintenance. My
Court
lord,
is left with no other option.
my lord. 6,000 is a little more high, my lord. 6,000 because the petitioner says that he is a coolie man. He is a coolie. He is not capable to pay 6,000 to the petitioner number 1 and 4,000.
Whether it is high or low, you had an opportunity to tell the court. You have chosen not to contest. Had an opportunity to tell the court. You have chosen not to contest.
No, actually, he had an opportunity to defend his case before the family court, but he couldn't defend it. Couldn't.
So what?
My lord, my prayer before the honorable court is that some amount may kindly be reduced and disposed of the matter, my lord.
Will not do it. Tell your client that the court is going to dismiss it. This matter tomorrow.
Next week, maybe.
Patil.
Yes, after lunch.
Yes.
My lord, may I make one submission?
No
That
adjournment.
serial number 110 will that become infractious.
Only infractional submissions
Please, my lord.
should be made. Nothing
110 will that. 110 will that. 110 will that. Writ petition number 10048 of 2023 will that.
110.
Howdo. The 10048 of 23 will that. The MC petition is already disposed on 8/7/2000.
Submitted the main MC itself is disposed of and the petition has become infractional. Dismiss.
Please, madam.
Serial number 119, my lords.
I'll come from this side, yes. Which one? 5 in the second list. Then comes for the petition, submits that the petition instructions, what MC is disposed of, or criminal miscellaneous. MC is disposed of. Nothing, that's not required. Yes. Yes. Which one? 99. Huh.
The likelihood of settlement for the matter is disposal of mediation. Likelihood of settlement.
When was it referred?
It was referred long back. Next year, second.
It is referred. April is April, May, June. 60 days are over.
So the deliberation was that he is ready to take leave. It is at that stage.
Lissus matter.
It is at that stage.
Lissus matter on 11th of August. By the time the council shall inform before the court, or else the matter has to be. Huh? Withdrawal. Withdrawal. 130. The main MC is 7320 of 2020 self is disposed of.
I'll withdraw the petition.
120 matter is already settled and they'll come up with the instructions. This is matter on Tuesday.
Serial
List number
93. The
90?
matter settled.
90?
List number 1, serial number 93. Matter settled.
Take that memo. What is that? It is a memo is filed stating that the dispute between the parties is fully settled. Yes.
My lord, serial number 100, my lords. My lords, the writ petition become infructuous, my lords. The main petition has been disposed of, my lords. Serial number 100.
Memo is there. Take the memo. Yes.
Serial number
Oblige.
106. Yes, memo is filed stating that the main matter is disposed. Yes, next.
Cause list one, serial number 170, my lord.
170.
170.
Yes.
Praise for time.
I specifically said don't ask for time. Only wherever there is 130 is not the time for asking adjournments. Yes. Only anything has become instructions. No mentions with regard to adjournments.
But insofar as the serial number 119 concerned, I am for respondent. Petitioner has paid only part payment, my lord.
If you mention it now, what the court has to do?
No. Can it be on Monday, my lord?
No. We'll call it and then we will adjourn it. Not just like that. Then we will adjourn it. Not just like that. I have to look at the order sheet. What has happened earlier?
Grateful.
Huh?
My apologies.
To file objection for memo of calculation, my lord. Next week.
My apologies.
I think the cause list contains that I do not entertain any request for adjournments at 1:30. In spite of the same, everybody is mentioning. It is so embarrassing for the court to say no.
My apologies, my lord. At one, I will make, my lord.
153 at the request of the land council. List on 6th.
Please, my lord.
My lords,
I'll do that. I'll pay
serial number 172, my lords. There is a connected serial number 172. There is a connected matter. Let it be listed along with that, my lords. Writ petition 5551.
Madam, court officer, madam.
Ready, sir.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 160 ಅಡ್ಜರ್ನ್ ಆಯ್ತಾ ಮೇಡಮ್?
160 ಇದೆ ಸರ್.
ಇದೆಯಾ ಮೇಡಮ್? ಓಕೆ ಮೇಡಮ್. 160 ಹೌದು ಮೇಡಮ್ 160
ಇದೆ ಇದೆ.
ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಯಾವಾಗ ತಗೋತಾರೆ ಮೇಡಮ್?
ಸರ್ ನಾವು ಕರಿತೀವಿ ಲಿಸ್ಟ್ ಮಧ್ಯಾಹ್ನ 2:30. ಯಾವ ಟೈಮ್ಸ್ ಎಲ್ಲ ನಾವ್ ಹೇಳಕ್ ಆಗಲ್ಲ ಸರ್.
ಅಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲ
ಬಂದಾದ್ಮೇಲೆ ಮೇಡಮ್ ಯಾವ್ದು ಕರಿ ಅಂತಾರೆ ಅದು ಫ್ರಮ್ 2:30 ಬಂದಾಗ್ಲೇ ಗೊತ್ತಾಗತ್ತೆ ನಮ್ಗೆ.
160 260
Court of, sir. Court of, sir. Court of, sir.
House matters, list number 1, serial number 14. Serial number 14.
Yes.
Mike use my Deepa.
The petition, in this petition, the petitioner has taken specific contention that the minor child is not his biological son. So, given by the petitioner, and the family court has also failed to consider that the wife has given a consent letter stating that after parentage of the child is proved in a DNA, she will claim maintenance. ಅದನ್ನು ಕೂಡ consider ಮಾಡಿ.
Please come. Agreed with the orders passed and criminal miscellaneous number 116 of 2022 dated in an application filed under chapter 10 within brackets paternity test that tests DNA read with section 151 CPC dated 20th May 2022. The husband is before this court. Minor son. That application is filed on 6/4/2018 and the husband has filed his objections on 25/10/2018 and the application for the DNA test was filed on 2/1/2010 to 2/1/2020. The court had dismissed the application on the ground that earlier the maintenance was granted to the son in criminal miscellaneous number 111 of 2018 and the recovery petitions are also pending. And the court has also looked into the aspect that till now the petitioner has not sought for any declaration that he is not the biological father of the child. Earlier, when he has given a missing complaint that the wife is missing, in that he has stated that the wife is 7 months pregnant and both of them are in cordial terms and leading cordial marital life. Further, the proceedings under 125 CRPC are summary in nature and prima facie looking at the relationship between the parties. The court had dismissed the petition. Then counsel of the petition submits that when the husband is denying the paternity of the child unless and until the DNA test is done. Unless the scientific evidence is on record, it would be difficult for the father to prove. Then it's what the counsel was a summary in nature, and also looking at the other factors, court had rightly felt that the application cannot be allowed, and this court finds no reasons to interfere. Dismissed.
Cell number 33.
Your Lordship, I tried to serve the notice to the copy of the writ petition to the counsel appearing in the trial court. So I have produced the memo, and Your Lordship may take the page number 22 of the memo, my lord, the last page. In the learned family court has recorded about this trying of serving the copy. Last page, my lord. Yes, Your Lordship. Order dated 27/3/2025.
This court has permitted the petitioner to take out the hand summons. When the petitioner counsel tried to serve the hand summons on the counsel has refused, stating that he has no instructions to receive the copies from the respondent. This is recorded on 23/5/2025.
27/3, my lord. Order dated 27/3.
2025. And again, the matter was directed to be called on 23/5/2025. Even on that day, the PW1 is present and the respondent is absent, and no representation from the respondent side. This proceedings reveal that the respondent is aware of aware of the petition that is pending before the court.
Appear for the respondent, white, my lords.
Your Lordship, in this matter, the impugned order, as per the impugned order, we were directed to pay 10,000 per month. I work as a broker in a real estate firm. There is no fixed income. I'm earning only 10,000 to 15,000 per month. Your Lordship had directed us to pay 6,000 per month, which I'm continuing doing. But it is not possible to pay 10,000 per month because I have a senior citizen mother. She's 75 years old. There is no child from the wedlock. And there is serious dispute regarding the income and assets and liabilities affidavit also. I claim that she is an MBA person. She's having 37,000 per month she's earning. She's claiming that she's only earning 27,000 per month and she's a BCom graduate.
27,000. How much is your income?
My income is 10 to 15,000. I'm working as a broker, so I'm not earning.
Why you want maintenance?
No, but it's, that aspect is wrong, my lords. In the affidavit, your Lordship may kindly
There
have
is-
there.
Please come to the order. We will read from the order.
Please,
Yes,
please.
Your Lordship.
Well, the reasons would start at para 6 minutes. Page 14 minutes.
Start from paragraph number 7.
Please.
Yes.
Your Lordship, there is dispute regarding the affidavit. That is exactly what
We
I.
can't do anything.
And
now.
we have
Lordship
also
can
filed a-
direct the family court to have an inquiry, and meanwhile, I'll continue pay 6,000 per month.
Doing when have you raised all these objections that time? You have not raised. No, we will not do anything.
That's-
I
we have-
will
we have
continue
filed
paying
an
6,000, Your
application.
Lordship. It is very.
Start reading from paragraph number 7.
When the case is posted for evidence of petitioner, the counsel for respondent has filed this IA number. We'll continue paying 6,000, Your Lordship.
I asked you to read. Please read. Complete.
The petitioner is least bothered about her and did not treat her as part of his family. The petitioner is the partner in home nursing service and earning more than 70,000 and also financing and had lent 30 lakh and the interest amount has received more than 30,000 per month. The petitioner has neglected her and deserted her without any justification or reasonable cause. He has dumped her in a parental house and now is leading luxurious life. She required a sum of 30,000 per month for her daily needs like clothing, food, healthcare. The petitioner has sufficient means and is also capable to pay the same. For all these reasons, she prays to allow the application in the interest of justice. On the other hand, the counsel for the petitioner has filed objection to IE number 3 in his objection and has denied all the allegations made by the respondent. And also he has specifically contended that after the marriage, the petitioner would try to fulfill all the needs and wishes of the respondent, but respondent would always quarrel with the petitioner by abusing and committing acts of cruelty. The respondent herself had refused to stay along with him and left the house demanding money to live separately. The petitioner has also filed petition under the provisions of Domestic Violence Act before 3rd JMFC Court in criminal miscellaneous 68/2022. The respondent herself is guilty of refusing to come back home and to stay along with him and his family. In spite of members and family members of respondent had talks regarding to settle the matter, the respondent refused to come back and to stay with him. The respondent is very cruel in her attitude and nature. The respondent was never interested in staying with him in peace and harmony. Now the petitioner is an employee at real estate office and earning salary of rupees 10,000 to 15,000. The respondent is MBA graduate and working in Shakti School, Shakti Nagar as an accountant cum HR and part-time job as an accountant at Bellissima apartment and earning more than 37,000 per month. And also she is working as an accountant at Gopal Krishna Temple. Shall I continue, Lordship?
Yes.
In the present case, the petitioner and respondent have filed their respective affidavits of assets and liabilities. On perusal of affidavits of assets and liabilities of the applicant/respondent, which clearly goes to show that she has educational qualification of BCom. She required general expenses of 14,000 per month. She has filed criminal miscellaneous so-and-so.
Come to paragraph number 14.
Keeping in mind all these principles, in the present case on perusal of affidavits of assets and liability of petitioner and respondent, which clearly goes to show that the respondent is working in MPB Private Limited as accountant and HR and her net salary is 27,000 per month. On the other hand, on perusal of affidavits of assets and liabilities of the petitioner, he has stated that he is doing work as real estate agent and his monthly income is of 10,000 to 15,000, whereas the respondent has stated that the petitioner is doing partner in home nursing services and he's earning more than 70,000 and is also made into finance and had lent 30 lakh and the interest amount receives more than 30,000 per month. Whether the respondent is earning as stated by the petitioner are different, which came to know only after full-fledged trial. As I've discussed above, merely because the wife is capable of earning, it would not be a sufficient ground to reduce the maintenance to the wife. Here in the present case, the petitioner has specifically stated in her application that she is residing in a parental house.
You are earning 27,000 per
Please,
month.
minutes, please.
And there is no evidence on record to show what is her income.
Please.
His income.
His income. No, minutes.
He says according to him, he is earning 10 to
Minutes. That is
15,000.
false for the reasons, my lords. In his affidavit of assets and liabilities, he shows his expense as 10,000. His income is also 10,000. How that is possible, my lords?
Because he is a mother, 75 years
I
old.
don't have to answer his
Minutes.
arguments.
He has suppressed everything in everything in his affidavit of assets and liabilities. I have also moved an application before the trial court for suppression of those things. My lordship may kindly have my affidavit, my lords, page.
What was the material placed before the court to come
Please.
to say what is the income of the husband?
Lords, I have stated in my affidavit at.
Not about your oral assertion. There
Please.
should be some material on record.
Lords,
Yes,
if,
while this statement comes to light, then you can move an appropriate.
my lords may kindly see. My lords may kindly see. He purchases a flat for 55 lakhs, my lords.
Where
After
is the
filing of
document?
this, please, my lords.
Where is the document?
No, my lords. I could not. I will produce. I have produced a sale deed before the trial court as well, my lords. What he does is immediately after filing of the present petition and my maintenance application, he executes a settlement deed in favor of mother, executing that property in her favor,
Then
and comes before the court and said
all those were not disclosed.
all those were disclosed. No, I have now filed I have filed all those were disclosed in my affidavit. He has not disclosed those things.
Place that before the court.
Please, my lord. I will place it. My lord. If 2 days time is not, I
Counsel
will
for the
place. Please,
respondent
please.
submits that the petitioner has come before the court with suppression and misrepresentation of fact. He'll come up with all the necessary documents. When
3 to 4 days time, my lords. Should come
this is a
to
matter
from
on 11th of August
Please, Lords. Most grateful.
Please, Your Lordship. Grateful.
List.
That 76 passover will be called later. Serial number 81. 81.
I filed application seeking amendment to bring subsequent events and documents in support of my case. And I think it was not listed in the morning, that application. Now the office has put up that application. That application may be kindly be allowed. And if the other side wants to file objections, an opportunity
What
given.
is that application?
Application is, Manad,
What is the prayer that is sought?
the prayer, Manad,
Let's see the original prayer.
original prayer is, Manad, is challenging the order passed by the trial court, granting interim custody of the ward on 2 dates to the respondents. The respondents are the grandparents. Granted my respective submission. Subsequently, the other documents are the ward is now admitted to the school in Bangalore, and pursuant to admitting of the child to the school, the a separate civil petition is filed, and the matter has been transferred
Please come to the impugned order.
impugned order. Impugned order is at Manad, page number annexure A, page number 11 onwards. Manad, the impugned order operative portion is at page number 22.
Respondent is hereby directed to leave her minor child by name so and so
Yes, ma'am.
to the petitioner's house
Yes,
on
ma'am.
every weekend, that is from Friday evening 5 p.m.
And
to
Sunday.
Sunday evening 5 p.m.
Yes, ma'am. She is a widow.
Where are they staying?
Sorry?
Where are they staying?
They are staying in rural area. Nagamangala, Mandya district is far away from 120
same-
kilometers. Sorry?
In the same place?
No. This lady was residing in her parents' house. At that point of, they are not residing together. The husband of the petitioner and the son of the respondent died.
Petitioner is the mother.
Mother,
Respondents are the
Grandparents.
paternal grandparents.
paternal grandparents.
Where is the mother residing?
Mother earlier residing in Pandavapura Taluk. It was around 70 or 80 kilometers away from the matrimonial home. And earlier to that also, the petitioner along with her husband, they were residing in Bangalore. Subsequently, after death of her husband, she was forced to go out of the matrimonial home. I mean, it's
This
parents' house.
petition is filed at Pandavapura.
Yes, ma'am. Pandavapura. They are residing in Nagamangala Taluk. It's around 70 to 80 kilometers away from our native place. Now this lady,
The address shown is the grandparents are staying at
Nagamangala Taluk.
Kasaba Hobli, Nagamangala.
Kallukumbari village, Kasba Hobli, Nagamangala Taluk, Mandya district.
Original address, what is the distance between both the distance between
Both
both the
around
places?
70 to 80 kilometers. She is presently residing in Bangalore. Child has been admitted to the school at Bangalore. And the matter before the Pandavapura court has been transferred to the Bangalore court. Now I have placed along with this additional amendment application, along with the documents, with respect to the receipt.
This is 80.
81. Madam.
Where is the counsel for the respondent? Yes, Mr. Harish Kumar.
Yes, please, my lord. Please, my lord. The counsel on behalf of the petitioner informed to taking adjournment, my lord, because morning itself was informed to me. Now they are arguing because I am held up in outside, my lord. I request your lordship, kindly 2 days time, I will come and argue the matter, my lord. 2:30 also, their counsel called informed to me taking adjournment.
On Tuesday as part heard. Yes.
Not my amendment application. Because this.
That is not necessary.
Yes, ma'am. I'll argue to substantiate my contention that the prayer sought by the trial court before the trial court by the respondents and the allegations made in the application and the subsequent development, they are requested.
We will be doing it in a JNWC final hearing. This is an IA as far as the
Yes,
interim.
ma'am.
We will not go into any other.
Yes, ma'am. Initially, in the morning itself, we start asking the adjournment of the matter since court has not considered prayer. And
Tuesday part heard.
Yes.
Next.
Serial number 82.
Obliged.
Kasina JD, Manjula D.
Should I pay for the respondent?
Appearing for the petitioner lordship. Lordship, in this case, a petitioner filed an IA number 5 summons to the five hotel registry book lordship. Lordship, in this case.
Where is the order?
page number 16, Lordship. Order.
You are for the wife or husband?
Wife, Lordship.
MCs of the year 2022.
Yes,
What
Lordship.
application you have filed?
This is conjugal rights, Lordship.
To issue summons to 5 hotels.
5 hotel registry book. Respondent has
Created in
been
the
demands to produce the registry book, Lordship. There are important documents to prove the relationship between husband and wife, Lordship. The trial court dismissed the same order, Lordship. Hence this Lordship.
So respondent is accepting that they're staying together, but only denying the marriage.
But there's a dispute as to the not the marriage. Please, not earlier, not the petitioner had married to one Mohan. Please, not they. She felt the petition.
No, I've seen everything. You accept the relation, but not the marriage.
Lord, they were in illicit relationship. Not
That's
together.
what.
Please.
Marriage you are denying.
Marriage is denying.
Please come.
Lord, kindly hear me. Lord, hear the case.
I'm dismissing the writ petition.
Please, Lord.
Lordship, kindly have it on tomorrow, Lordship.
No.
Or pass over, Lordship. They are denying the relationship between the husband and wife, Lordship. Not only marriage.
Why you want to
Denying
argue?
the
Why you want to
relationship,
pass
Lordship.
over? Why you want to argue? Why you want to pass over? There are so many matters. You would have morning you asked for a passover.
Yes, Lordship.
It is passed over.
Yes,
You
Lord.
started argument.
Yes,
Court heard you. Passing
Kindly have
orders.
it on tomorrow, Lordship. Or pass over, Lordship.
Lord, I just want
They are denying the relationship,
But
Lordship.
they say MC number
281 of
Please,
2022.
please.
281 of
22.
Dated 10/9/2024, whereby the court had dismissed an application that is filed by the husband, filed by the wife, under order 16/06 of the CPC, to issue summons to 5 hotels situated in the neighboring districts to produce the room registration books maintained by them. The wife has filed the petition seeking for restitution of conjugal rights. Husband has denied the fact that the marriage has taken place. According to him, they were in relationship, but the marriage was not solemnized. Now, the wife wants to place before the court wants to summon the register from the 5 hotels to show that both the parties have resided in the said hotels. The court has dismissed the application, observing that the whole purpose of allowing the whole purpose of the respondent is not denying the relationship between the parties. However, he is denying the fact that the marriage has solemnized. The documents that are sought to be summoned have no nexus to the have no connection to prove that the marriage is solemnized, when the respondent himself is admitting that they are in a relationship.
Lordship, in OS case 334 of 2020, there is no marriage. Is there in some injunction order, Lordship, for related marriage? But respondent husband denying the relationship between both, Lordship.
There are 2 aspects.
Yes, Lord.
How is it connected to this? Now an application is filed. Now you want a particular register to call for to show that both of you are residing together. He is not disputing it. Why do you want it to summon by wasting the court's time? There is no dispute on that. You both of you staying together will not prove the marriage. Marriage is in dispute.
Detail respondent objections is in detail objections they doing deny the relationship between
But
relation.
in fact, my lord, she got divorced.
Deny the
The
relationship.
court has recorded that he is accepting the relation.
Please, Lordship.
Yes.
And the respondent himself admitting that they are in relationship.
He is denying the marriage and that they were in a relationship. What is that before? It is a discussion part. Read from 4-5 lines before.
The relationship between the parties, however, he is denying that the marriage was celebrated. That means the first act to be summoned have no connection to prove that marriage is celebrated. When the respondent himself admitting that they are in relationship.
Oh, that is observation of the court. That's what. Oh, that is observation of the court. That's what I'm asking. Of the trial court. And accordingly dismiss the petition. When counsel appearing for the petitioner submits that those documents are very crucial to prove the case of the wife, and the court without considering the same dismiss the application. When counsel for the respondent submits that the court had rightly dismissed the application and those documents do not prove the marriage which is in dispute between the parties. Next paragraph. Having read the counsels on either side, there is a material on record. The petition herein has filed a petition seeking restitution of conjugal rights. According to the respondent, there is no marriage solemnized between the parties and they were in relationship. In fact, she was married to some other person.
Please, that was divorced in the year 2020.
So the court has rightly observed that by calling for those registers, it cannot be proved that there is a marriage between the parties when the respondent himself is admitting that they were having illicit relationship, and the court had rightly dismissed the petition and no grounds to interfere. Accordingly dismissed.
73 pass over. Gaurav. Vijayta Nayak for respondent.
My lords, I'm requesting for a short accommodation.
They have made me to wait till now.
The senior was here,
I have left-
but
I
because
have
the
left
file
my
was
all
sent
work.
back to the pending branch, so
Why it is sent to the pending branch?
I
It will come. They said that it will come. Why should
He's
the
stuck in
senior-
the argument before
He is made
another
to
court,
wait.
my lord.
He is made to wait. Nobody told you that matter is not called, will not be called.
My lords, like short,
They only
kindly
got-
list it
They
tomorrow.
only got pass over.
Tomorrow, my lords.
On
He's
cause,
stuck in.
on cause for making him wait till now.
And
No, that's not right. Don't ask for Passover when you cannot do it.
we apologize, my lord. An interim order is extended.
I'll not extend the interim order. I'll only adjourn the matter
My lords,
for the inconvenience caused to the other side.
no cost may be imposed, but interim order let it be extended. Thank you.
That's, I have
This
left my
matter-
all works unattended. Please.
Hmm?
I had to go to family court for argument.
Who?
I left to go to family court for argument.
Who?
I left my.
In you, what to do now? We can't hang them for that. List this
12:30
matter.
12:30
When do you
was
want? When do you want? Tomorrow on Monday?
Tomorrow itself.
Tomorrow, list this matter tomorrow. At the
Cost may,
request
heavy
of
cost may be imposed.
Huh?
Heavy cost may be imposed.
My lords, we are asking only for a day's accommodation.
Tomorrow, at the request of the counsel, the petitioner interim order earlier granted is extended till then. Yes. 2:30 matter.
230 matter.
Acha.
230.
Now,
I went there, my lord,
we
but
are,
the file
we
was
already,
sent to the
for
board.
everybody, it is a problem. Let's not do it. All the office objections have to be complied with.
Today itself I'll clear it. Today itself.
And they shouldn't have listed before the court. It's my specific instruction. Because this office objection, you will be complying it in 2030.
I'll complete today itself.
Yes, what is the matter?
Lord's petition is responded before the trial court, my lords, wherein the impugned order of 23-6, my lords, 25,000 has been ordered as a maintenance, my lord, for the Millennium.
You're selling something, some urgency, something has happened.
Lords, they have initiated another execution, my lords, for regarding this. The matter of 29/8/2024 to till now to 2,50,000 rupees. The earning is itself only, my lords, of around.
No. This is an order of 23rd June 2025.
Yes, yes.
What is the urgency for to take up this matter at 2:30?
NBW has been issued as he has not paid the amount, my lords.
Not this amount.
My lords?
Not this amount.
This amount, my lords. They have separately executed another CMIS for recovery of this amount, my lords.
No, there is a time for appeal also, for revision also.
Where, my lords?
This order is passed on 23rd June 2025. You have a right to file a revision against this order.
No revision has been filed, my lords.
No, you have a right to file a writ petition.
Writ petition I have. No, I have.
Yes. I can understand.
Yes.
You are telling as if like there is no time for you.
Yes.
I can understand.
Yes.
You are telling as if like there is no time for you and they are going to execute it right now.
No, because
order is passed on 23rd June.
Yes, madam.
You can file a writ petition. There is at least reasonable time would be there for you to file a writ petition. It's not even just a month. When did you have the copy of it?
It's already of a month. It is.
You have the copy on. Copy was made ready
4/7
on 36/2025.
4/7 minutes. It has given on 4/7.
Order is on 23rd June.
Yes. 4/7 it has been.
Which order you are challenging?
23/6 minutes. That is at page number 46.
Yes, date of order. Look at the date.
It was. It's 1023 of 25 minutes.
Criminal miscellaneous
1023 of 20.
23 of
25 minutes.
25. When is it filed? When the warrants are issued?
That information I don't know.
But without that information, how did you move a matter at 2:30? As if like heavens are going to fall.
No,
That's not right. The moment you get a brief, not necessary that we have to pass orders.
No, not like that, my lord. I have not made any such kind of thing.
Then,
only the thing is that
no, you are saying that as if like warrants are issued, it's going to be executed.
The briefing council also told me NBW has been issued because he is.
When you said, no, when you're saying you should say that. Yes, we'll see tomorrow. When your matters have to be taken out of the turn, there should be a basis. Just like that, we can't take matters. Yes, tomorrow.
Yes.
From serial list number 1, ma'am. Continuation. List number 1, serial number 90. Ashok B. Patil, for petitioner.
I am for the petitioner.
Yes.
The impugned order is in Kannada language. The entire impugned order. I am required to file a translated copy of it.
Then counsel for the petition submitted the impugned order is in Kannada. We'll file a translated copy by 19th of August. List the matter on 21st.
Right.
Yes.
Serial number 91.
For petition.
Serial number 91.
For petition, my lord.
The puppy.
Lord, petitioner is seeking, my lord, the enhancement of the maintenance, my lord. Only 5,000, my lord.
What is granted by the trial court?
5,000 to the petition number 1, my lord, and dismiss the petition of petition number 2, my lord.
Petition number 2 is?
Mother, my lord. Petition number 1 is the minor child, my lord.
Why? Why it is dismissed?
Saying that, my lord, one of the decree judgment and decree with regard to the restitution of conjugal rights. For that reason, they are rejected, my lord.
Yes.
My lord, with regard to the harassment made by the respondent, my lord.
With regard to
For harassment, my lord.
that you should not tell this court. You should
Assault
tell
and other things, my lord. For that reason, she could not rejoin the husband.
You should have questioned that order of restitution passed by filing an appeal. You cannot go before the other court and say that because of this harassment, because a competent court has already passed a judgment.
That was the ex parte judgment that has been challenged, my lord, in the miscellaneous petition. That is also produced before the trial court, my lord. That was the ex parte judgment, my lord. The ex parte.
What happened to that?
Miscellaneous petition is pending, my lord.
Which year is that? Once let it be decided.
Judgment.
Then you can Then you
Judge-
can revive that, your request for maintenance. As of now, there is a judgment and decree, we will not consider for the wife. And come to the case of the child. And what is the income of the father?
My lord, income of the father, my lord, 60,000, my lord.
Where do you get that?
My lord, working chimney based skill worker, my lord.
Come to paragraph number 23.
Though the contention of the petitioners that the respondent is earning more than 1,35,000 per month, absolutely there is no material before the trial court, before the court to substantiate the said contention. However, during the cross-examination, the respondent has stated that his monthly income is about 7,500. He is not having obligation of maintaining any other dependents except his wife and child. But the disclosure affidavit filed by the respondent in terms of the direction issued by the Honorable Supreme Court of India in Rajneesh versus Neha, the respondent has fairly considered that he is getting monthly income of rupees 20,000 from the chimney work. Absolutely, there are no material either to disbelieve the said contention, to hold that, or to hold that the respondent is getting much more.
You can't have in this. You have to file an appropriate petition. Agreed with orders passed in criminal miscellaneous number 433 of notice is not ordered.
Notice not ordered, madam.
What is happening from 22?
Not, it was dismissed earlier, my lord. Thereafter we have filed the recall application. It was recalled.
The registry is directed to issue emergent notice. This is matter after service of notice.
Then number 92, Revana Siddhappa, for petitioner.
For representation for dismissal on 6th of August.
Cell number 93 disposed, 94, MV Maheshwarappa.
Same order.
Cell number 95.
Yes.
Ravi Kumar, NR.
After the petition. This is a petition, my lord, against the order passed by the trial court, my lord. The respondent number 1 is the wife and 2 and 3 are the children, my lord.
How much is granted?
8,000 to the first petitioner and 3,000.
First petition is wife. First petition is wife.
Wife, my lord.
8,000 and to the children?
8,000. And for the children, 3,000 each, 14,000 total is awarded, my lord. And
What is your income?
my income, my lord, he is working in the school bus driver in the private school in Chikmagalur. So he is getting only 18,000 and 19,000.
See that. Please come to that.
Prior to.
Let's see paragraph number 14.
Please, my lord.
Correctly taken, 25,000. Driver though will get the 25,000 at least.
Please.
Next.
The petition number 1 has continued that the respondent is having house and site properties, but there is no evidence to regard the income of the respondent. In the absence of evidence, it is held that the monthly income of the respondent 25,000 per month. That is only a guesswork made by the trial court, my lord. He was getting 25,000.
We'll make it 12,000.
Kindly, what is my submission, my lord? The mother is having ailment and heart patient also. Every day he is looking after the mother also. That is hardly. I request your lordship kindly to the extent of 10,000, my lord. Only that extent I request.
Please come. Agreed with the orders passed in criminal miscellaneous number 66 of 2021 dated 1st September 2022. Husband is before this court. The court had granted maintenance of an amount of rupees 8,000 to the wife and 3,000 each to both the children, and that is an amount of rupees 14,000. It is a case of the husband that is working as a driver and the court has taken the income at 25,000 and granted the maintenance of 14,000. Then counsel for the petitioner submits that in that 24,000 he has to take care of himself. He has to take care of his mother who is ailing, and he has to spend a lot of amount towards the health, the medical expenditure of the mother. It is submitted that the court had granted more than half of the 60% of his income towards the maintenance, and it would be difficult for the husband to pay the said amount. Though notice is served on the respondent, there is no representation. Next, for having got the counsels on either side, there is the material on record, the facts and circumstances of the case. This court is inclined to grant an amount of rupees 10,000. Accordingly, the order dated so and so is modified, and this court is granting an amount of rupees 6,000 to the wife and 2,000 each to both the children. Yes, next. Yes.
96. Serial number 96.
On the last occasion, the matter came up on 24/8/2023. There is no representation. Today also there is no representation. This is matter for dismissal on 31st.
Serial number 97. Inaction.
Senior class on the next start code was next week.
You should argue the matter. Why next time?
Senior
Finally, this is the matter on
Next
12th,
week
no, 12th August, no further adjournments. Yes, 98,
Number 98. HP Rudresh.
no representation for dismissal on 12th of August.
Serial number B group 99, 90, 100. Disposed. 101. Keshav M.
Till
Datta.
101, my lords, appearing for the petitioners. Due to some personal income, senior is unable to come today, my lords.
This is the matter on 12th August, no further adjournments, no representation on behalf of the respondent.
The respondents have already been informed that.
Yes, they don't write that.
102.
Pledged.
Sumati, yes, for petitioner.
No representation for dismissal on 14th of August.
Serial number 100.
I have to place those materials before the Honorable Court.
At the request, this is a matter on 6th August.
Please.
Serial number 106 and 7 disposed. 108. Vinod Kumar M.
There's no representation for dismissal on 5th August.
Serial number 109. Sidmalappa PM.
Same order.
Serial number 110 disposed. 111.
Same order.
Serial number 112. Kamath and Kamath.
And for the petition, my lords, this petition is arising out of section 24 maintenance. It's for the
Yes.
the petitioner and respondent had having a two child, my lord. They're both are majors. The elder son, he is with the respondent, and the younger son is with the petitioner. Now, the elder son is aged about 27 years, my lords, and this the maintenance was ordered on 2023.
As on that day, what was his age?
Minutes.
As on that day, they were all major.
They were major.
Then
They
how
were
did
major.
the court grant?
Actually, they are mentioned for the education purpose, my lords, but now he is into the business and is earning.
See, let us see where is this order.
And we have produced an annexure D.
Order.
And we have produced an annexure D, my lords.
Order.
Annexure A.
Please come to that order. The application is allowed. The petition is come to that order. The application is allowed. The petition is directed to pay 8,000 per month each to the respondent and her elder son towards interim maintenance and educational expenses. Maintenance to the minor will be enforced till he attains majority.
Minutes. Not second person.
It says maintenance to the minor will be enforced till he attains majority.
No, my lords. The younger son is aged about 21. He is with the petitioner. Petitioner is
Elder one.
Elder one is with the respondent. My lords.
Please come to the cause title. Where is the cause title? Before the court. So where is the petition filed before the court below?
Lords, we have attached into IA in Annexure B, my lords. Annexure D is the birth certificate.
No, that Surya, when is his date of birth?
1998 minutes.
Complete date.
16/8/1998.
16/8.
1998.
And when is this petition filed? For maintenance?
For the maintenance 2021 minutes.
2020, my lord.
2020.
9/7/2020,
20.
application is filed. my
Then
lord.
how old is he by that time?
My lord, because he is not educated, there was the petitioner father has not taken care of the education of the elder son, my lord. He is not well
First of
settled.
all, in the MC, what is this maintenance to the son?
My lord, an application was filed for maintenance of the mother and the children because the children were in the custody of the mother, my lord. And now there is a stay. Father is paying maintenance only for the wife, my lord, because it is his special petition. No other maintenance is being paid.
So
my
we will
lord.
consider as far as the mother is concerned.
My lord,
Maintenance as far as mother is concerned, we will consider that.
that one 8,000 rupees is being paid, my lord. That's all.
Then that
Apart
won't-
from that, nothing is
That
paid.
can only be considered. That only will confirm.
My lord,
What
I
is the
may-
difficulty for the mother?
No, ma'am. Even she is earning, my lords. Even she is doing a tuitions. Even she is earning.
You have not questioned it. We have not questioned the date.
instructions to me. Any day next week, my lord, I will make my submissions.
This is a matter on 19th. The request of
The Lordships,
Interim order is.
interim order earlier granted is extended.
My lord, with
That's
your
obvious.
Lordship's permission, can I make a submission? The previous matter, my lord, I was held up of court number,
Matter.
the previous matter, 104.
What happened to that?
That, my lord, that matter has become infractious. The parties have settled the 104. Arun Purnappa.
Land council submits it for the main MC itself will dispose of.
Yes, yes.
Yes. Dismissed as instructed. Yes.
Then number 115, so 1314 disposed, 115. Gopal Krishnamurthy C for petitioner. Suhita Singh.
Section 24 application, my lord. The
Counsel of the petition is present. No representation for the respondent. There's some matter on first.
lord, interim order may kindly be extended.
Interim order is extended till then.
Grateful.
Yes.
Then number 116, Raghavendra K.
My lord, I'm
Petitioner.
supposed to file NOC wakalat, my lord. Supposed to file NOC wakalat, my lord. You want this, my lord. I'm not receiving.
You already filed.
Akki Manjunath.
No, my lord.
Niti Nayamma.
Huh?
I am a new advocate, my lord. for the
Christiana
What is
NOC. New advocate she is.
Correct.
telling.
There are two names here.
Niti Nayam.
Nitin AM.
No, my lord.
Hmm.
I'm the new advocate.
What is
A
the name?
petitioner.
For respondent, my lord. My name, Priya, my lord.
Whoever is filing the wakalat, what is the name of the advocate?
Pennu illa.
When do you want?
1 week time, maybe.
A week's time. Let's the matter on 7th. Yes, next.
Then number 117,
Before petitioner, this matter has been settled out of court before the mediation center. Only we have to report it. Kindly, it may be dismissed as
Then
not.
counts the petition submits the matter is settled before the mediation center, and they're going to file a report, file a settlement memo.
Please.
Considering the same, the petition is dismissed as infractious.
Great.
Yes.
Cell number 118. Pradeep Kumar RH. Dismissed.
What is this matter about?
Maintenance that is granted.
This
6,000,
patient,
they're asking for enhancement.
no representation for the petitioner. Then counts for the respondent is present. List the matter for dismissal on 31st.
Serial number 119. Hemant Kumar GM. Hemant Kumar GM.
Yes. Yes.
Your Honor, order is being complied with. 10,000 is paid every single month.
Plus 19,000 is awarded. Plus this honorable court may say while granting interim order lots 10,000.
10,000.
Because as
It has to be argued now. Both of you are here.
Yes, yes.
One more time.
Plus 15,000 granted for the child, my lords. And he is earning more than 1,50,000.
Yes.
Another day may be granted. A senior is not well, so I.
So when do you want?
Tomorrow.
Tomorrow itself.
Tomorrow.
The counts for the petitioner submits app. Counts for the petitioner seeks time. This is the matter on 5th. You argue on 5th. You argue on 5th.
Yes, sir. Much obliged.
120. BF Kumar for petitioner.
Counts for the petition is present. No representation for the respondent. On list the matter.
Appear for the petitioner in this matter, madam. Seek for a short
Appear for respondent in this matter, madam.
Yes.
That's, in this interim order has been passed for monthly maintenance of 20,000.
Complying with it?
I've complied, madam. 25% also I've deposited.
Interim
It is
order.
compliant, madam.
Then counts for the petition submits of the interim order is complying with. Then list this matter on 12th of August.
Interim order may be extended, madam.
Interim order is extended till then.
Great.
Number 124. Ketan Kumar.
Appearing for petitioner, Your Honor. 2 weeks time.
My lordship, the main petition is dismissed.
When?
August 2024. I have not
Counsel
received
for the
the.
respondent submits of the main petition itself is disposed of in the year 2024.
Yes, my lord, August 24.
And nothing is suffice for consideration. This petition is dismissed.
Serial number 125 disposed. 126 adjourned. 127. MR Nagabhushan for petitioner. Madhu.
For respondent, madam. Will file a written objection, madam. File written objection.
No objections are required for this. Where is the counsel for the petitioner?
MR Nagabhushan.
Yes, like in this other order, no representation for dismissal. Yes.
Serial number 128. Nagarajas for petitioner.
Appearing for petitioner. Both the petitioner and respondents have filed 113B application before the trial court. Mediation for.
Coming up? It's ordered.
Yes, ma'am. Kindly have it on next week, ma'am.
This is matter, it is submitted that already they filed a compromise petition before the court. List this matter on
Interim order, ma'am.
13th of August, interim order earlier granted is extended till then. Next.
Serial number 129.
Annexure K, madam. K.
6,000 and
Yes, ma'am. And 2,000 rupees each.
additional expenses of
Pardon me? 2,000 each is awarded
children
to
are entitled for a maintenance of 6,000
each.
and another 2,000 each for the education.
Yes.
That is 10.
Yes, ma'am.
Then the future interim maintenance will be paid with honor before so and so. One-time litigation expenses 20,000. What is the husband's income?
80,000 rupees.
Salary slip is at page 65, my lord, annexure F.
No, from the order,
Same, my lord. From the order,
which paragraph you can find it?
page 12, internal page 12, my lord.
Hmm.
Page 13 is the first portion, first line.
Yes,
Paragraph 14, my lord.
his
On the
gross
other-
salary is 57,000 and net salary is 36.
Ah.
Hmm.
And another 20,000 rupees is pension, my lord. He is a retired army person.
Now, this daughter also attained majority. When?
One had already attained majority when the application was filed.
But then how the court has granted?
It was granted, my lord, no challenge is made.
Pardon?
As on the day when this order is passed, one of the daughter has already attained majority.
BSc study ಮಾಡ್ತಾರೆ.
She was 22 years old.
She is studying in BSc.
Hmm.
And the second daughter is studying PUC.
Till the age of marriage.
Section 125 of the CRPC.
But still, there are judgments to that effect. That even instead of filing another application, the Guardian Moths Act, they are entitled for maintenance till the daughter.
And my lord, he is also getting pension as a retired Indian Army
How
personnel.
much? How much?
And 19,000 for 140 rupees in the year 2021, my lord.
Not doing
Now his
anything.
pension is enhanced, but he did not disclose the document, my lord.
No, as on that day, what is the age of these? What are they studying, both the daughters?
Pardon?
Both
One,
the daughters, what are they
one
studying?
has already completed her graduation, my lord, because she was studying in the final year when the application was filed. The other one would have started her graduation.
PUC.
She was studying PUC back then. Should have.
Lord, the section 125 of the
What do you
CRPC, my lord.
say on the application filed in the MC? Filing an application in the MC, what do you say for maintenance of the major children?
Application. Annexure D, my lord. Annexure D, application.
Family court, sir. Yes.
Lord, I have taken 3 grounds, my lord.
No, the income is, or what is the pension is receiving?
Still 90,000 rupees as on record, my lord. 2021, 19,000 to 140. In the year 2001, now his pension is enhanced, but he did not produce the
Then
latest
what is the
document.
other salary you are saying?
Bank, my lord, is P1, 57,248 rupees.
Take home is?
Huh?
Take home salary is?
36,000.
As per next sheriff, my lord.
Hmm.
Kindly see.
36,495, my lord.
Deduction some others.
How much is granted now? How much is granted now?
10,000.
10,000
Yes.
to all of them.
Yes.
Right. The finding given is that the wife was also getting some amount in her account that has not been disclosed. That is why the maintenance grant is 10,000.
How
That
much
is
is
the-
getting in her account?
Kindly see the annex at G, my lord.
No, the children, no.
There's an
If that head of, maintenance to the children is not stated, and if she says that the so-and-so amount is required to take care of the children. Two daughters and the mother, 3 people.
please.
Yours with your pension and with your salary, not taking 50, but only 36, still it is about 56,000. Court has granted only 10,000. We'll enhance it by another 10,000.
The reasoning given by the trial court is that.
Come to that.
Please. In the trial court has relied on Annexure G, my lord, that is at page 66.
Joint account.
It's an account in which about 19,000 and all.
First, what we do is we'll read this.
Please.
This order. Where is that? Where the court had discussed about
Please.
it?
At internal page 12, my lord, page 108 of the petition.
Yes.
Yes.
Here, from the second line, thereafter from September 2018, rupees so-and-so has been credited continuously till February 2019. Thereafter, from April 2019 onwards, an amount of rupees 18,164 for each month has been credited. Further, in the month of so-and-so, an amount of so-and-so is credited. Applicant has nowhere stated either in her application or in her affidavit filed for disclosure of assets and liabilities that what is that amount which is credited to her account for every month. Hence, the petitioner having contended that the respondent is working in private school should be taken into consideration as the respondent did not explain with regard to the amount credited for every month to her account, unless it is some gainful payment to the salary. There is no chance of such an odd amount of money being credited. Continuously, the credit entry is from so-and-so. This is the reasoning given.
Kindly see, my lord, paragraph 25 to my ground, my lord. The learned trial judge of the family court has committed serious error in noting that the petitioner herein has drawn certain amounts from the joint account opened in Punjab National Bank, is Annexure G. It is not doubt true that there is joint savings bank account in Punjab National Bank in the name of the respondent husband and the petitioner. However, the petitioner used to draw the amount through ATM card provided by her husband in his
That amount you were withdrawing from his account.
joint account. That account only the pensioning amount only credited.
Please come.
The trial magistrate, judge of the family court, my lord, for this Annexure G is the
I number 4.
petitioner account on the mistake.
2021, dated 14 September 2023. The 5 years before this court, seeking enhancement of the compensation, enhancement of the maintenance. The court had granted an amount of rupees 6,000 to the 6,000 and educational expenses of 4,000. Altogether, an amount of rupees 10,000 is granted as maintenance. It is a case of the wife that is getting pension of 19,140 and also getting a salary of 57,248.50. The court had considered the entries in the
joint account. Annexure G, my lord.
Had considered the entries in the wife's account. That is 18,164 to 23,500 on different months. And court has come to the conclusion that she has suppressed the fact that she is working and had not granted maintenance to her and granted maintenance to the children. Then counsel submits that when the father is, when the husband is earning 69,000, around 70,000 and odd.
80,000.
The court ought not to have granted, had granted maintenance of 10,000, which is on the lower side. Then counsel appearing for the respondent submits that when both the children are majors, they are not entitled for maintenance. As on the date of the application, question the order impugned. It is submitted that though the salary is 57,248, but the take-home salary is 36,496. Court had rightly considered the income of the wife and rightly not granted granted maintenance to the wife and granted maintenance only to the children. He submits that no interference is called for the said order. It's fair. We heard the counsels on either side, but is the material on record. The husband has not questioned the order of the family court and the contentions with regard to that their application under section 24 is not maintainable. Daughters cannot seek into those issues. This court is not going into, but still, if both of them are residing together, it's a responsibility. Both the parents will take care of the responsibility of the wife, and whoever is earning will take care of the needs of the children. So when the wife is not in a position to maintain herself and the children, then it has to be, then the husband has to take care of them. Even considering the take-home salary and the pension is getting as being an ex-serviceman, still the amount of 10,000 that is granted by the court as maintenance is on the lower side. Considering that the daughters and the mother has to take care of themselves, this court deems it appropriate. Before that, as far as the entitlement of the mother is concerned, court considering the entries in her bank account had not granted the maintenance. Then counsel for the petitioner drawing the attention of the court to the particular statement, it is submitted that it is a joint account, and from the joint account he has drawn, and court had considered as if it is her independent order is modified.
Till number 130, Ajay Prabhu for petitioner, Ranjan Kumar for respondent.
130.
I seek, my lord, a week's time, my lord.
Why?
Lord, to obtain some documents in this regard.
What documents? Writ petition? No document. Please come to the impugned order.
Lord, this is a application filed by the wife for amendment of our 125 petition. My lord, she wants to bring, my lord, the.
Where is the impugned order?
Yes, my lord. Annexure A, my lord.
Page number?
Page number 16. Lord, before this, my lord, the husband had filed, my lord, restitution of conjugal rights after 4 years of separation.
Let's read from paragraph number 11.
Please.
Yes.
It appears that
Who is respondent?
Husband. Respondent is husband. Yes, ma'am. Before trial court and in this petition. It appears that married, my lord. Married. It appears that respondent herein filed MC number 161 of 2019 for restitution of conjugal rights, and after filing of said petition, she filed MC number 361 of 2019 for divorce. Unfortunately, both the said matters were not tried together, as MC number 161 of 2019 was made over to this court, whereas MC number 361 of 2019 was made over to First Additional Principal Family Court, Mangalore. After trial, this court, by its judgment and decree dated 29/7/2022, decreed MC number 161 of 2019 and directed the petition number 1 herein to restore the matrimonial relationship. On 25/11/2022, MC number 361 of 2019 came to be dismissed, holding that petition number 1 has failed to establish that she was subjected to cruelty by the respondent by hearing. It is admittedly nowhere under CRPC any provision is specified to allow a petitioner to amend her pleadings. It is rightly argued by the counsel for the petitioner that though the maintenance proceedings are governed by provisions of chapter
What
9.
is the amendment that is sought?
Milord?
What is the amendment that is sought?
Yes, Milord. Amendment application is Milord, is at Milord page number 80.
Page number?
80, Milord.
Hmm. Hmm.
Just to Milord, it is just to Milord to bring to the notice of the court that Milord, taking advantage of his own fault, Milord, he has filed conjugal rights. I mean, in spite of filing, Milord, the
No, what is the purpose of this amendment?
Milord, that he is heavily relying upon the Milord decree of restitution of conjugal
No,
rights.
whatever material you place before the court,
Please.
the court granting this maintenance you can't get over the judgment and decree in a summary proceedings. Court cannot consider all that. No, there is a decree of restitution. That means without a reasonable cause, you are staying away from the husband. So in 125 CRPC
Not
proceedings,
because, kindly see Milord the decree, Milord. I have produced the judgment.
no, there is a restitution. Let's not go into how and where it is.
No, Milord, because I'm trying, Milord, to bring Milord's attention to this. Because only because the restitution of conjugal rights is allowed.
Neither this court nor the
MF is filed on the Milord decree.
that you argue. For
Yes,
that, all these are not necessary.
Yes,
You
ma'am.
need not prove that there is cruelty on the part of the husband. When there is a restitution decree and your MC for divorce is dismissed, saying that there is no cruelty.
No, Milord, not that reason, Milord. But only because restitution of conjugal rights is allowed. My petition for divorce,
No, that
because
is
Milord,
allowed. That is allowed. This is dismissed.
what is alleged in the Milord petition is Milord, the advocate one who has appeared for the petition.
Which is dealing with 125
Milord,
CRPC.
it will not change any nature of the Milord my
Why should you
petition.
do it then? Then waste of time. Now
Milord, but Milord, it is the
already-
fact.
Trial has commenced. If it is not changing anything, why should you do it?
Milord, kindly see Milord the amendment.
Yes, I've seen it. Not necessary. Please come.
But Milord, if trial court going to Milord relying upon that judgment, I have to
Of course,
bring
It has to.
even after Milord the decree. Milord, he is causing Milord
That is not the
threat.
concern of the court.
Milord, kindly see Milord, my amendment is that. Kindly see 21C also, Milord.
You are not understanding. In a summary proceeding, how can the court decide all that?
Milord, the finding of the trial court is that Milord, kindly see Milord the page number.
No, I will not look into the finding of the trial court. That is already MFA you have filed. MFA court will look into it.
No, not that, Milord, in this petition.
I've seen that order.
Milord, where
Now I understand what you want is by way of this amendment, you want to tell the court, though there is restitution there is a decree of restitution, and my petition for divorce is dismissed. Still, I am entitled for maintenance because there is an act of cruelty on the part of the husband. That is what you want to prove. Court has rightly said that it can't go beyond the judgment and decree that is already passed in a full-fledged trial. And there is no purpose of amendment. Please come.
Milord, insofar as Milord that concerned, there is Supreme Court judgment where it says, Milord, that
But once 125 CRPC proceedings are concluded, then you can come to the court relying on the judgment. Not at this
it is
stage.
regarding Milord Reena Kumari versus Dinesh Kumar Rao. Milord, the judgment of the civil court means the restriction of conjugal.
Amendment cannot be allowed. I will not go into any other. Not necessary. Agreed with orders passed in criminal misdemeanors number. Order in.
At least, Milord, for my satisfaction, Milord, I may read this paragraph, Milord.
Yes, read.
Milord, on para number 18, page number 62, Milord.
Yes, read.
On perusal of judgment passed in MC number 161 of 2019 and copy of decree that is in exhibit R1 and exhibit R2 also clearly goes show that though RW1 in her evidence in the said case had made allegation that due to alleged husband given by her husband. She sustained injuries and several times she has taken treatment from the hospital, and even she lodged a police complaint. But petitionarian has failed to.
Even assuming that every finding of the court in that MC is wrong, it has to be set aside by a competent court.
Please.
How can it be in a summary proceedings? How can you make the court say that this MC or the judgment and decree is wrong? So you please decide now whether there is cruelty on the part of the husband or not.
My lord, there is no pleading of such, my lord, regarding my petition in the MC petition, my lord.
Agreed with orders passed in I number 3 in criminal miscellaneous number 107 of 2022, dated 13th October 2023, where an application filed by the petitioner seeking amendment of the pleadings is dismissed by the court. The petitioner before this court is the wife. Parties are referred to as wife and husband. Wife has filed an MC, husband has filed an MC seeking restitution of conjugal rights, and the wife had filed a petition seeking divorce. The petition that is filed by the husband seeking restitution of conjugal rights is allowed, and the petition filed by the wife seeking divorce is dismissed. Seeking divorce on the ground of cruelty is dismissed. The wife had preferred an MFA, and the same is pending consideration. The wife has also filed criminal miscellaneous seeking maintenance. In that, when the matter is at the stage of the trial, after the by way of this pleadings, the petitioner wife wants to incorporate the pleadings stating that the husband has committed the act of cruelty. The court, by order impugned, had dismissed the same on two grounds. One is that such an application is filed at a belated stage, and nowhere it is stated that, and at a belated stage after the commencement of the trial. And it is not the case of the petitioner that, in spite of due diligence, all these facts could not be brought to the notice of the court.
I've stated, my lord, I was not informed by the trial court advocate.
Then the second ground on which the court is recorded, I'm recording the court's findings.
Yes.
Court said it or not?
Please.
The second finding is that even if this the amendment that is sought is not necessary, and it is not necessary to decide the dispute between the parties. Next para. Learned counsel appearing for the petitioner wife submits that already the judgment and decree in restitution is all, and the judgment whereby the decree of divorce, the MC filed for divorce is dismissed. The MC filed for divorce is dismissed against both the MCs. MFAs are filed, and the same are pending consideration before this court. The husband is trying to take advantage of the judgment passed in a restitution case, and as such, the wife wants to file this application seeking amendment of the pleadings, and to bring to the notice of the court that how the husband has committed cruelty on the wife, and which made the wife to stay away from the matrimonial home. And in those circumstances, it has been stated in the petition that in spite of due diligence, this aspect was not brought to the notice of the court. Then counsel submits that the court ought to have allowed this application as it goes to the root of the matter. Next para. Then counsel appearing for the respondent husband submits that court has considered all the aspects that are placed before the court, and particularly the fact that as of now, the judgment in the restitution of conjugal rights, the decree is staring at the petitioner, and further on the wife, and further the amendment of the pleadings will not have any effect on the merits of the matter, and it rightly dismissed the petition. Next para. Having heard the counsels on either side, peruse the material not record. The admitted facts in this case are there is a judgment and decree passed in a restitution case, restitution of conjugal rights, that is filed by the husband, and the MC that is filed by the wife seeking divorce is dismissed. Appeals are pending before this court. Now, this application under 125 CRPC would be decided by the court whether the wife is entitled for maintenance or not. Because the husband is relying on a judgment and decree passed in a restitution case, now the petitioner wife wants to amend the pleadings and prove before the court that there is a cruelty on the part of the husband. As such, she could not join the husband. When already a judgment and a decree is passed and after a full-fledged trial, the court will not, in a summary proceedings under 125 CRPC, will not conduct a roving inquiry and find out that whether there is a cruelty on the part of the husband or not. If the petitioner wants to get over that or has already filed an MFA and to stay away from the matrimonial home or not. Now the case is at the verge of trial, and at this stage the proposed amendment is neither necessary nor it can be permitted by the court, and the court had rightly dismissed the petition, and this court finds no reasons to interfere. Yes, next.
Serial number 137, 130,
One minute.
131, 131. V.V. Kulkarni.
Counsel for the
Appear for
respondent is
one
present.
respectful submission, my lord. This writ petition is filed seeking transfer, my lord. Kindly look at the prayer for a moment, my lord.
How these petitions are numbered?
Please.
Give the file. The writ petition is filed
Seeking transfer from Chikbalapur
to transfer the petition filed by the respondent, that is MC number 104 of 2022 before the district judge, family court at Chikbalapur. To the district judge and family court to the family court at Bangalore.
in view of section 20.
1 minute.
Serial number 132.
Lords, I appear for petitioner in second matter, Lords. Lords, need short accommodation, Lords. I am unwell, Lords, today.
Lords, please, I have no objection for the
Yes,
adjournment.
at the request of the land council, the petitioner. This is the matter on 19th August.
Obliged.
Obliged, Lords.
133, Ramesh Kini, for petitioner.
Appear for the respondent.
Yes.
Wife's petition. Amendment application was been dismissed. That is why I filed writ petition.
Let's see the impugned order.
At page number 14, my lord, reason starts from page number 14. In a petition for divorce, after her cross-examination, she files this application.
Who filed the MC?
Wife files the MC on the ground of cruelty. After her cross-examination, she files this application. She wants to add certain cruelty that has been caused to her during her wedlock.
Why all these facts were not stated at that point of time?
That reason,
Come to the petition.
Petition may kindly be seen. No?
Where is
At
it?
page petition annexure B at page number 24. The reason why she has not stated is at page number 28.
So first of all, let us see what she wants to state.
Yes, ma'am. The application may kindly be seen annexure D at page number 37.
37.
Yes.
Hmm.
Amendment sought for.
Hmm.
From second line, my lords may kindly see. It's very cruel. I don't feel like reading also.
Please come to the main petition.
Main petition.
Hmm.
Page number 24. Relevant portion is read. Para number 13, page number 28. my lord. There are certain matters which the petitioner does not intend to state at this stage and reserves her liberty to say at proper time.
No. Any of, in the first petition, did you refer to at least on like about the conduct of the husband?
No.
Maybe you have not elaborated it. Where did you say so?
My lords may kindly see page number 41, my affidavit, 41.
Yes.
Para number 6 from third line. I was feeling embarrassed to disclose all the facts which are narrated by way of amendment, and I
No,
was.
this is which year? MC is which year?
MC is of the year 2023.
When did you find this IA?
2022, sorry. 2023 I filed this IA.
What is the stage?
There is an interim order, that is why
What is the stage? As of-
immediately after cross-examination I filed this writ petition. There is a stay.
So the trial has commenced.
Yes, trial has commenced. Immediately
So
after
your cross-examination is over.
my cross-examination is over. I
Yes.
wanted to add these
Is over.
my cross-examination is over. I
Yes.
wanted to add these points and
How can
prove
it
the
be?
cruelty.
How can it be? You are now, the issues are set for trial.
Yes.
Now, basing on the pleadings, evidence
No,
will be
his
let in.
evidence has
Now,
not
at
yet-
this point of time, what is this?
Now his
no-
evidence has not yet started, my lord.
Hmm.
So I wanted to bring these facts because these facts prove that there is cruelty. And my lords may kindly.
Your ground on which you want divorce is nothing related to these allegations.
No, but these allegations are very important for deciding this
That
matter.
is so, you would have stated in the main petition.
The reason I did
So
not state.
Why this has come, at what
Where is
stage?
that? Where is
My lord, my lord gets it at page 43, page 43 annexure email.
Paragraph?
Exactly paragraph 8, my lord, at page 44. It is submitted that the proposed application is an afterthought intended to embarrass, humiliate and insult the respondent. These allegations are not whispered in the first notice issued on behalf of the petitioner dated 4/7/2022. Again, these allegations are not made in the petition filed under the DV Act, leave alone in the petition in this case. These astounding allegations are made admittedly on the advice of the present counsel because there was change of counsel after that. In fact, in the main petition at para 6, it is alleged that respondent always so and so in a room and failed to fulfill his matrimonial obligations, which amounts to cruelty. My lord, having said all this, would your lordship kindly see for a minute objection statement, my lord. Her petition, in her petition, at page 26, my lord, paragraph 6, I don't intend to read this, my lord. One sentence, kindly read, my lord. Respondent so and so.
Yes.
Failed to. Having said all this, my lord, both are the teachers in a government school. They had a very good relationship, and the husband always wanted the wife to be with him. He said, even at this stage, he says that let her come. I have a child. We are respected people. He is respected for his nobility and also his conduct in the school and
No, let us
social.
see the reasoning given by the court.
Yes.
My lords may kindly, before that, my lords may kindly see page number 38, my lord.
30?
Just 38.
Mm.
Point number 13.
Point number?
2020. So I have evidence. It's not that simply.
An important aspect. It definitely has a
No,
very
what happens
important
is-
aspect, particularly with regard to cruelty. That cannot be,
No, what
that
happens is,
cannot
my
be
lord-
stated by way of an amendment after the trial.
The reason she did not say, my lord, she thought there'll be a settlement as soon as.
How about this paragraph number 6? Just now he has read.
Yes.
How is it going with this amendment? Is it not you're setting up altogether a new case
No,
by way
nothing.
of amendment? You never said so with regard to any kind of sexual harassment by the husband.
That is
No,
why I
you're
want to
setting up a
bring.
new case, which is not permitted, it cannot be permitted by way of amendment. Please come to the impugned order.
Impugned order is at Annexure A,
Yes. Para 13.
para 13. Admittedly, in this case, the trial court has commenced and commenced already. The petitioner has fully cross-examined the PW1. Now the matter is posted for further evidence. Therefore, the first portion of so and so is not applicable. But whereas the proviso of the said provision is applicable, as already the trial has commenced and now the petitioner is seeking amendment of her pleading in which she is intended to plead some more new facts contained in several allegations made against the respondent for so and so and so and so, so and so. Therefore, it is necessary to find out whether the petitioner, in spite of due diligence, has failed to incorporate these allegations in her pleading, either at the time of ending or before commencement of trial. Now, this para number 14 is very important, my lord. It is necessary to keep of trial. Now, this para number 14 is very important, my lord. It is necessary to keep in mind that petitioner is not an illiterate or an ordinary woman, but she is well educated, her qualification so and so, and since last 7 years she was working as a teacher. She is if she was illiterate or a housewife, then the matter would be different. So what trial court says is, if she was illiterate, I would have allowed the application. She's not illiterate, that's why I dismissed this application. It is pertinent to note here that on so and so, just 20 days before filing of the petition, she got issued legal notice and she had not responded, making allegations against him about the matrimonial harassment and cruelty. To her counsel, she did not state anything about the said allegations, which is now incorporated way of pleading of amendment. Admittedly, the petition was filed on so and so. It is pertinent to note that on so and so, after 5 or 6 months of filing of the present petition, she has filed this DV proceedings. In the said petition, she has just intended to desire so and so. In the DV proceedings, she has already stated, madam. That may kindly be seen at page number 18, para number 15.
Yes, I've seen, I've read the entire order. It's altogether a different story you are introducing. Already there is a basis for these pleadings in the earlier petition. And some of that you have not mentioned that you can understand. Altogether a new
Because
story
what
you're
happens is, my lord,
introducing.
I cannot prove this without stating this allegation. And prima facie, my lord, by seeing these.
But the allegations which you are making are not so simple that you forgot at that point of time.
No, the reason I did not state it because I thought there will be a settlement. I thought.
You have decided after your examination is over.
No.
Please come. Agreed with the orders passed in I number 6 in MC number 367 of 2022 dated 16th November 2023, whereby the court had dismissed an application filed under Order 6 Rule 17 by the wife. The wife is before this court. Parties are referred to as wife and husband for the sake of convenience. MC number 367 of 2022 is filed by the wife seeking divorce on the ground of cruelty. In the petition, she has stated about in the petition at paragraph number 6, she has stated like this, extracted page number 26, para number 6. And she has raised several allegations against the husband about how he is behaving, to the mental and physical cruelty. Then she has narrated about the baby shower ceremony and how the things went on on those occasions. As her life has become miserable with the petitioner, with the husband, she has filed the MC. When after her examination, she has come up with this application to amend the pleadings. By way of this amendment, she wanted to introduce new pleadings stating that the petitioner is interested in unnatural sex and also about several allegations about the manner in which about his sexual orientation, and also the fact that he has sent the objectionable videos to his brother and the same were with her. So unless and until these facts are brought on record, it's difficult for the wife to prove the cruelty of the husband. The same was resisted by filing objection by the husband, wherein he has stated that there is no basis for these allegations, and after commencement of the trial, she has come up with this application. By way of this amendment, she wants to introduce altogether a new story, and which is not permissible. It is submitted that the court, in the objections, has categorically narrated how this application is not maintainable. It is submitted that the courts on the ground of cruelty. She had narrated several things in day-to-day life by which such acts amounts to cruelty. In the petition, at any of she has nowhere stated about the sexual life and the other behavior of the husband. In fact, at paragraph number, I asked you to extract that. Again, it's paragraph number 13, she had stated so. Now, looking at the amendment that is sought, and by way of amendment, the new facts that she wants to introduce are completely contrary to her pleadings in the petition. Now, these kind of pleadings, if they are allowed, they cannot be allowed. Now the trial has commenced. Once an application is filed seeking amendment after the trial, the petitioner has to say, the party who has come up with the application has to say, that has to ever and prove that in spite of due diligence, these facts could not be brought to the notice of the court at the earliest point of time. There is no such pleading. Why it is not stated in the earlier while filing of the petition? At this stage, this court, the court cannot allow these kind of pleadings, which are contrary to the earlier pleadings and which would cause prejudice to the other side at this stage to be allowed. In the considered opinion of this court, the trial court had the family court had rightly considered all these issues and had rightly dismissed the petition. This court finds no reasons to interfere.
Cell number 134 discourse, 135. 135.
I am for the rest in favor of the wife, my lord, sir. My lords, even today, my lords, the petitioner has not completed the order passed by the Honorable Court, my lords, while granting the stay. He has not paid the arrears of maintenance, my lords. There is a child, school-going child is there, my lords. Even he is having 5 to 6 lakhs arrears of maintenance, my lords.
This coordinate bench of this court had granted where is the interim order?
My lords, interim order is that the stay order granted by this Honorable Court, my lords, in the first instance, my lords.
A coordinate bench of this court directing the maintenance of rupees. As far as is concerned, the same is stayed. However, the stay is subject to the condition that the petitioner shall pay 30,000 during the pendency of this petition. Then counsel for the respondent submits that so for the order passed by this court is not complied with. There is no representation on behalf of the petitioner. This is matter for dismissal on 30th.
May make one submission.
Much
Not by virtue of the order dated 22/2024, the Honorable Court had directed me to get communication from the Regional Passport Officer, Hyderabad, whether the petitioner has two passports or not. This Lord, the instructions is this, my Lord. I have placed it on the other day. Lord,
When is the order?
Order dated 22/2024, 22/2024, my Lord. 2024. Lord, upon verification by the regional passport officer, Hyderabad. Please, my Lord, it is found that he has got only one passport. Therefore, my Lord, the
On instructions, Mr. Shanti Bhushan submits that. And the communication that is addressed also placed before the court. Only presently having the passport, one passport, that is passport bearing Z6842208 dated 22/11/2022, which is valid up to 21/11/2032. We delete the name of Mr. Shanti Bhushan.
One submission, my lords, in this regard, my lords, one submission, my lords. My lords, this passport, whatever produced by the petitioner, my lords, my allegation is that, my lords, he got second marriage. Your lordship may kindly come to that passport, my lords. He has not produced second page of that, my lords. Second page, my lords, the spouse name has been mentioned, my lords. Intention is not produced, my lords.
This matter on 30th for dismissal.
Great.
Yes, next.
136.
Yes.
136, Girish.
No representation. This is a matter on 19th of August. Yes. It's okay, not for dismissal, list on 19th of August.
Yes. Tell number 137. Sharat S. Gogi,
My lords.
petitioner.
On 12/3/2024, this honorable court had ordered to pay maintenance of 30,000. Petitioner has been paying since 30,000. Petitioner has been paying since that date, my lord. There is no arrears pendings, my lord.
Because notice is served already, you have to argue on the merits of the matter.
Yes, my lords. Kindly give some time, my lord.
This is the matter. It is submitted that the interim order is complied with by the petitioner. List this matter on 20th. Yes, next.
Meanwhile, interim order may be extended.
Interim order on all the wherever interim order is there.
138. Suma.
No, the extension of maintenance, my lord.
Is there interim order in this?
No, my lord.
No, counsel for the respondent.
139.
I represent the petitioner, my lord. It is a husband's petition challenging the impugned order dated 30th January 2020.
This is the matter on 31st. Yes.
Number 140.
My lord, can't it be next month, my lord, after 15th?
Why?
Anyhow, she is not appearing, though the notice is.
Because it is served, we can dispose it off. Yes.
At least first week any date, my lord.
First 140. I appear for the petition.
I appeal for respondent, my lord. It is only for maintenance of 30,000, only for child, my lord. He is drawing 2,35,000.
Lord, I have not questioned the maintenance. I have not questioned the maintenance.
You have not?
I have not questioned the maintenance. I have paid the maintenance. I have not questioned it.
Honorable court has directed.
What is question?
Lord, what has happened is two applications were considered together. My application for custody and or visitation.
What is the order on your custody application?
My lord, that is this. My lords may kindly see
Give that.
order. It is at page 20, ink page 28, my lord.
20?
28. Lord, on page 27, the learned judge makes an observation. The respondent is presently staying in USA. This is not correct. And on the basis of.
So ultimately, the order is the respondent is entitled for visitation rights. So and so whenever he visits native place of the child.
My lord, I am living
and
here
he is
only.
directed to comply the order as per the convenience of the petitioner as well as the respondent.
Yes, ma'am. I am living here only. I am never gone out of.
What is the age of the child?
Now it 12 and a half years.
12.5 years.
I have not seen him for last 8 years.
You are in Bangalore.
I am in Bangalore.
How much maintenance you're paying?
My lord, I am paying whatever has been ordered. I have not questioned it also in this petition.
No, but they are paying only 15,000. By this
Lord,
honorable court,
even
it has been
before-
reduced to 15,000.
Lord, I am
30,000 has been paid, madam, by the trial court. Now it has been reduced to 15,000 by this interim order.
By an interim order. But you say he
My
has
lord,
not questioned
whatever
it.
has been ordered by the interim order has
No,
been.
but you were when you are not questioning why should we reduce it? About the
Visitation.
then we will
Visitation.
dispose of this matter.
True, my lord. It can be done. That observation that I am living out of India is not correct. And on the basis
Counsel
of
for
that.
the petition father submits sir, is residing in India. As far as the maintenance of an amount of rupees 30,000 as ordered by the court, he has no objection to pay. However, as per the interim order passed by the court, he is paying 15,000. It is submitted that he is not able to see the child from the last 8 years. Now he is aged 12.5 years old. How the visitation should go on?
Any conditions, madam. I will abide by any condition by this honorable court, madam.
He's saying something.
My doors are open all the time, madam. Anytime he can visit.
No, not that way, my lord. My lord,
Since from
that is the issue, my lord.
2017,
I have been
my lord.
assaulted by her father.
Where is she residing?
Bangalore only, madam.
Where? Which place? Apartment or where?
Lord, where the address has been given, she is residing there only, my lord. His father's house, my lord.
It's not about the address,
Yes.
sir. Just to say to how the visitation has to go on, I'm asking where is she residing? In an apartment,
In Girinagar, there's a father's house, madam.
independent house.
Independent house.
One near to that, any malls are there?
Yes, ma'am. Actually, parks and temples are there. Temple would be a good place.
My lord,
Ma'am, I just
my
have one
sug-
No, no. What we do is initially for 3-4 times, meet,
Very well, my lord. I
meet
am-
somewhere where the mother and all, as you said that you are not seeing him from the last 8 years. So let him not be taken by
Lord, for
surprise.
the Brahmopadesha, my lord, the father was not there. He is in Bangalore.
My lord, we have sent an invitation. We have
Anyhow,
called him.
let's not go into all that. The petitioner, the order dated 13/8/2024 passed by this court is modified. And the petitioner the father shall continue to pay 30,000. If there are any arrears also at 30,000.
3 to 4 months. I'll
You know,
make-
whatever it is, has to be paid, the arrears has to be paid Saturday and Sunday. Huh?
If my child is attending classes, I would request for one day.
No, let's see for this, from evening, Saturday, Sunday, let it go on for 4 weeks, then we will change.
Yes.
On Saturday and Sunday, between 3 to 5 or 3 to 6,
3 to 6.
between 3 to 6. And with regard to the place and the mall, the father shall communicate with the mother. This is matter on 28th. Let
Great.
this go on till 28th of August.
Grateful.
Yes.
From this weekend itself, not.
It starts from now itself. So weekend comes, whenever it comes, it's.
My lord is there from this week.
No. When the
Otherwise,
order
they-
is passed, that's on every Saturday and Sunday. So it starts from this weekend. Yes, next.
141.
Appear for third respondent, my lord. The petitioner, my parents have filed a,
Virenna Tigdi.
that is order has been passed.
So the petitioner is, the counsel the respondent is present, no representation. This is matter on 7th of August,
Much okay.
Cell number 142.
not for dismissal, normal. Yes.
142 Syed Khalil Pasha.
Petitioner in this case, madam.
Yes.
This honorable court passed the order in 23/2024, madam. Paid the maintenance monthly to
How much is the
20,000.
maintenance that is granted by the court?
30,000 was
granted.
30,000.
For
This
the
honorable court
education of
passed
the
it.
major child. 30,000 rupees for the education expenses of the 2 major children.
No, 30,000 plus educational expenses.
No, only 30,000 towards education expenses for major children was granted.
What is
On
the
the ground in
income?
the writ
What is the
petition.
income?
Income is 1,88,000
No,
rupees.
madam.
He's
Kindly
working
see,
as
madam.
chief manager of
Annexed
State
D,
Bank of
madam.
India.
And
Salary certificate is produced.
Page number
Page number 49.
49. What is the salary?
Net pay take home
You have 1,24,000.
1,80,000. After deduct the amount 58,120. Yes, my lord. Housing loan,
Housing
child,
loan,
child education loan also deducted, my lord.
At the time of disposal of this.
Child education loan also.
Get that.
Yes, my lord. Play taken as Monday, my lord. Here's the matter.
Tuesday.
The only ground in this writ petition is that.
We'll hear it on Tuesday.
Please, my lord.
Interim order may be extended. Interim order may be extended.
Interim order
What is
already
ordered
granted. Is extended till then, huh?
Interim order is already granted.
Yes.
Ten.
Yes, ma'am.
Till number 143, Rashid Khan, for petitioner.
For the petitioner. Weeks time may be granted, my lord.
Interim order is there in this?
There is no interim order. They filed for the enhancement of the maintenance amount.
Enhancement of maintenance.
Please,
The list is smarter.
because my lord, one submission. After 21st of August, there was a matter posted for orders. We filed the application for the
No, this is with regard to enhancement. What is the?
enhancement
connection with
because we filed the application for reconsideration of the maintenance amount.
It is
Before the
not
trial court,
giving
it was,
maintenance also, my lord.
it was posted for the orders on 21st.
This is matter on 22nd of
Please.
August. This
Much of-
144.
Much of-
144,
Petitioner, my lord.
SV Prakash.
My lord, I have written a letter to party, my lord. It's not served, my lord. It is not served. Therefore, 2 weeks time may be granted. Therefore, 2 weeks time may be granted.
Why letter any interim order is there?
Earlier, it is automatically vacated.
Vacated, then you can argue on the merits of it.
Party is not having written the letter, my lord. Therefore, 2 weeks time may be granted. Otherwise, I retired.
It's submitted that the parties are not in, or else you file your retirement memo
Right.
by sending it.
It is not served, my lord.
It is submitted that the parties are not in touch and it seeks 2 weeks time. 2 weeks time is granted. Next,
Till number 145, Sagar V. Shastri for petitioner.
Been petition challenging the interim maintenance as an interim order, your lordship, and I've also complied with the condition, and it's also been served on the.
26,
Appear for the petitioner.
Chandana Tariga.
Matter is posted on 2/8/25 for reporting settlement before the trial court. May I request it after 1 week, my lord? If they arrive at
submitted that the
settlement,
matter is posted for settlement before the court on 2/8/2025. There's a matter on 6.
Till
Please.
number 147, Balakrishna. Okay.
Yes.
Actually,
Interim order is there in this?
No, there is
No interim order.
meaning.
The list is smarter.
But, may I submit? This is with regard to the visitation rights of the child.
Hmm.
And now the matter is sealed in Supreme Court. Because he had filed a similar application in Anantapur. That matter came to be dismissed, and in the High Court, there was an order granting visitation.
We'll see when the petitioner council is there on Tuesday. List the matter on Tuesday.
Till number 148, Prasanna VR.
Petition in this case, my lords.
Interim order is not complied. They have not been
Lord,
paying 10,000.
For the last 4 months only, I could not pay the amount because of the ill health of my mother. Lord, she left the matrimonial home only to avoid the, Lord, to look after the, she is only the person who was looking after my mother. Lord, therefore, Lord, in order to avoid such a, Lord, fact, Lord, she has left the matrimonial home along with this child, with my child. Lord, as per the interim order, I have complied the Lord, direction, paying the maintenance. Only for the last 4 months, I could not pay. But then, Lords, both Lords, I am working as a police constable, Lords, whereas Lord, she was working, Lord, as a beautician. Lord, she has completed her BSc graduation in fashion design, Lords. She has not disclosed the same, Lord, in her declaration affidavit.
Well, you comply with the interim order. When are you
Lord,
going to comply?
Lord, 2 weeks, Lords, may I?
Then only
Lords?
we'll hear the matter.
Please.
This is matter. This is matter.
4
after
months,
4 weeks.
Lords, I am told.
This is matter after 4 weeks. By the time if the interim order is not complied with, the main writ petition itself will be dismissed. List the matter on 12th of August.
Please.
Interest of counsel respondent. Counsel for the petition submits that the interim order is complied with. Next,
And interim order may kindly extend.
they'll extend in all the matters.
Till number 151, Jay Shetty B.
For the petitioner in the case, Your Honor.
150.
Petitioner.
150, Your Lordship, I am for the petitioner, Your Lordship. I pray for an accommodation, Your Lordship, for in 150 serial number. Interim order has been complied.
They submitted to the interim order is complied with. This is the matter on 31st.
Your Lordship, after first week, Your Lordship, because senior counsel is admitted in the hospital, he has undergone an operation.
Seventh.
So moreover,
Seventh we will take up, it's 24 matter, yes.
151. Vijay Shetty B.
Where for the petitioner in this case.
Counsel for the respondent served, we'll have it tomorrow.
It may be 10th on August.
Huh?
My senior father-in-law was expired today. He is out of station.
This is the matter on 13th of August.
13th of August.
Yes,
Number
ma'am.
152.
Interim order extension.
152 Karthik Yadav.
1 week time, Your Lordship. I am proxy counsel, Your Lordship. He is due to health issues, he could not come today.
Adjourned. 154. Cell number 154 Mohan Chandrati.
On 19th August.
Cell number 155.
Appearing for the petitioner.
Here for the respondent.
Your
But the
Honor,
petitions become infructuous.
Yes.
Settlement talks are going on between the petitioner and respondent. Time.
This is already over.
No, we have already filed a mutual consent petition.
The
Yes.
disputes between the parties are amicably settled. Nothing survives.
It's getting
Consideration
settled, Your Honor.
dismissed as infructuous. It's next.
156. DJ Singapore.
I'm offering for petition.
May I please, for the respondent in this case.
I comply interim order or dated.
This is matter on 11th of August.
Please.
Cell number 157.
Pray for the respondent.
Satish.
This is matter on 13th of August.
Cell number 158. Nataraj.
This is a husband petition that though husband has earning 41,000 as per the salary certificate, net income, trial court has ordered 30,000 plus education cost, and there was a one-time.
Stay is granted by this court.
No, my lord. Because reason is why I'm insisting for interim order is that the petition is.
Not now insisting, what are you doing from 24?
Actually, I appeared before this court. I sought for interim
Yes.
order.
In this case, only notice was ordered in this case, no interim order was passed. And it will have to be heard and decided. Your lordship may kindly have it next week. It may be heard and disposed.
The matter
Only
on-
concern is that my lordship,
On 7th of August.
7th of August.
my lord, date may be.
7
Much.
of August. 59.
Here for
Dinabandhu.
the petitioner. Wife filed the enhancement petition, my lord. Trial court granted 3,000 rupees, my lord, to child. The education cost, my lord.
This is the matter on 29th.
Cell number 160.
My lord, I appear for the petitioners, my lord. Kindly 1 week time may be granted, my lord. The council is residing in the house.
Kindly have it on tomorrow, my lord.
Tomorrow.
Kindly, except tomorrow, my lord, any date, my lord, because she will come a day after tomorrow. Yeah, Monday, any date, my lord.
30th. Yes,
Much
sir.
My lord, any start date may be given, my lord, because.
30th is short date only next week.
Please.
Cell
Much
number
obliged.
161.
Much obliged.
Mohan
For the
Kumari.
R1 in this case, my lord,
Petitioner, my
when
lord.
the matter was posted for the argument, they came and took the stay, my lord.
1 week grace time, my lord. Interim order may be
When
extended.
is it posted for argument? We took time where?
My lord, in the session, my lord.
Here.
Hemant Kumar K.
163 on 29th.
Serial number 164.
Senior counsel is not well. Any date? For the response.
164 on 19th.
Much.
Serial number 165.
For the
165.
respondent petitioner has filed the 5,000 as
Interim order is there in this?
no interim order. I
No
filed
interim
for
order.
the enhancement of the interim order.
This is a matter on 13th August.
And kindly, my lord, one submission. They have not paid the interim maintenance amount. That is 5,000 awarded by the trial court.
13th.
Please.
That's why all these matters are
Please.
listed. So
Please,
to give a
please.
date and hear
Please.
it. Yes.
Number 166.
I appeal for the petitioner, my lord, challenging the annexure M, my lord, 28/6/2024, partly allowed, my lord.
This is matter on 14th of August.
Interim order may be extended, my lord.
167 MJ
For
Alpha.
the petitioner, my lordship, interim order is complied, my lordship.
Interim order, the council submits the interim order is complied list on 5th of August.
Interim order may be extended.
Serial number 168.
Yes.
Short accommodation, respondent, short accommodation.
I have the benefit of interim order.
This is the matter on 21st. Interim order earlier granted is extended.
Great.
169.
169. Varadarajan.
I appear for petitioner, my lord. The two more petitions are pending, my lord.
Take that numbers
Please.
along with those petitions on 22nd.
Serial number 170.
Praise for
Hearing for the respondent, Your Honor.
Yes, any interim order in this?
Yes, sir.
Have you complied with the interim order?
Interim order has been.
Yes,
extended
is
last
the
year.
interim order complied with?
Yes, yes, Your Lordship. They have paid the arrears.
Submitted that the interim order is complied with. This is matter on 22nd.
Serial number
Grateful,
171.
Much obliged.
Complied.
Maybe
It is
extended.
submitted, the interim order is complied. List the matter on 21st of August.
Please,
Yes, 174.
Serial number 174. Bhushani Kumar.
Interim order is not yet not there. Not passed.
Not
This is the matter on 5th of August.
Serial number 175. P. Nehru.
This matter on interim order is there. Look at it.
The respondent, my lord. Interim order is not there, my lord.
Not there.
Actually, the order has become infructuous, my lord.
How?
The order of custody of the children was granted from 4th April to 31st May, my lord, as per order dated 17th of April 2025. So the order has reached finality, my lord.
The order impugned is passed, whereby the mother is directed to go hand over the custody of the minor daughter on 4/5/2025 at 10 a.m. till 5 p.m. on 31/5/2025. And the father was permitted to pick up the daughters from the house of the mother
Please.
on 4/5/2025 at 10 a.m. and drop them back on 31/5/2025 at 5 p.m. As this is an order pertaining to 4/5/2025 and 31/5/2025. Nothing survives for consideration in this petition.
Lordship, appeal for the petition, sorry, I was late.
I think there is this order already worked out.
Yeah, confirm the, set aside the order.
Confirm. It is
Set
already
aside the order, please.
The petition becomes infructuous, dismissed. Yes, please.
Petition number 2.
No, set aside the order of the,
No, that is already over, lion. In the month of May, that order
yes,
is.
my lordship, but they have given the order.
Particular day order is passed.
Yeah.
The day is over. What is, no, there is no need to pass any orders from that. It will be there. Because you have not complied with the order as on the day, and you have not obtained any stay from this court. So either way, contempt.
My
will be
lordship,
there.
actually, the order was passed on 17/4. Immediately, we came on 29th
There is no
April.
interim order.
My lordship,
When there is no interim order, you are supposed to comply with the order of the court.
yes, my lordship.
That
Actually-
then it becomes.
No, no,
because
actually,
it is-
after this, we have gone to the court and then we have complied with the order for 3 days.
order on
We
merits,
have
sir.
sent the children for 3 days as per the order of the division bench, my lordship. No, we have complied.
How, you already complied with the order.
Yeah, 3 days, because there is no
If it
file.
is
with-
complied, then what order has to be passed now?
Because, no, the children were asked to be with the father till 31st of May. The school was reopening on 26th of May. So judicially, the mind was not applied while the order was given. That is what my contention is.
That is already over, that period
No,
is
it's all over, but
Anyway, if you want orders, list this matter tomorrow, I'll pass orders. The
Yes,
same
ma'am.
order I'll record and tomorrow I'll pass a recent order on this.
Yes,
Yes,
ma'am.
next.
much obliged.
Serial number, list number 2.
These two part-heard
part-heard
matters, these two part-heard matters on Tuesday.
Serial number,
Petitioner, it's a
Yes,
GM PDS matter, my lord, it is.
what is that?
59.7,
PDS
sir.
matter?
Separate roster, my lord, I'm ready to argue the matter if there is.
What is this?
PD, Public Distribution System Control Order.
It has come before. this
That's
court.
why, my lord, I am making submission.
Why that?
The
being a
lordship is
part-heard
ready to
matter?
hear, I am ready to argue the matter. Why, my lord, I am making submission.
Why Why that
Your
one
lordship is
apart
ready
from
to
that?
hear, I am ready to argue the matter.
Why it isn't part heard?
That's why I don't know. I never argued the matter before your lordship. This
First
matter.
time for issuing notice preliminary
Oh.
objection.
This never come before.
He is listed as part heard when I have not even heard.
Never listed before this court, according to me. I was surprised when I received the list.
Some record, something they have written.
That's why I'm waiting for that.
Hmm?
2493.
One minute.
ಆಮೇಲೆ ಮಾಡಿಸಿಲ್ಲ ನಾವೇನು ಮಾಡಿಸಿಲ್ಲ.
This matter was not listed before any.
24943.
No, 1 minute.
For the protocol, it was listed for twice, my lord.
Quashing the impugned order dated 6/8/2022, passed by the first additional principal judge family court
Yes.
at Mysore
No,
on IA number 3.
No, but it is classified as PDS, your lordship. That is the problem.
No, that is maybe that it's a mistake there.
Yes.
But the matter is pertaining to the family court.
But then no problem. I will check it up, my lord.
Yes.
Yes.
This is matter on 11th of August.
My lord. My lord, list number 2, serial number 2, my lord, part heard matter.
Not first matter, I'm saying.
Madam, file is.
Second matter.
2, Arun Govindraj.
Appearing for the respondent, my lord. My lord, the matter may be taken up tomorrow, my lord.
Tomorrow may not be possible on Monday,
My lord, Tuesday.
Tuesday.
My lord, there's also writ petition number 15181 between the same party.
That number post along with that.
Much obliged, my lord.
Yes.
Number 3.
No, there are two writ petitions, my lord. I will furnish the number to the court officer.
Yes. Yes.
Obliged.
Number 3, Adjournment.
No, this is already posted along with the other matter.
The council is here, ladies.
3 and 6.
Yes.
IPF respondent, my lord. Notice has been served to me and the trial court respondent.
So and so
advocate.
submits that, take her name, is as instructions to
I'll
file
file my
wakalat
objections and.
on behalf of so and so. It's coming up on when?
Monday, Lord.
Monday.
Monday, it's not possible. We have to write the objections like anything. 500 pages petition. Petition itself is 150.
Why he has filed all new documents, not before the trial, they are not before the trial court?
Yeah, they are before the trial court. They are themselves are there. He himself is the petitioner in that court.
What I'm asking is, if he is filing the documents that are before the trial court, when you are coming, when it is on an interlocutory application, why do you require to file the objections? That I'm not able to understand. Court is looking only at the interim order that is passed on an interlocutory application.
That has been passed in the January. Now, yes, now.
No,
Yes, narrated
Facts are the
something
same, leadership. We have taken the orders from below. The same facts
Not
have been
only the
narrated.
orders,
Now,
my
this is the conduct, leadership. All, they want to
I got
delay
the
the matter on
objection.
subtext. Now, the only
So
concern
the
is,
difficulty is,
let
if you
the child
start,
be
if you
brought-
start filing the documents which are not filed before the trial
Then
court.
that's not the
it is
case.
not there.
All
In
the
other
pleadings,
case,
all
you can
the, see,
I'm wanted to.
In your 1 minute, he is the petitioner, let the matter come on Tuesday. Your objections
Monday,
required,
leadership.
Monday or Tuesday,
Monday.
objections required, we'll grant the time. We'll hear him on the day,
Yes.
because he is a petitioner.
And I'm
Yes,
getting no access to
yes,
this file.
yes, yes.
With your lordship's name, again, the previous matter, no, it is wrong, your lordship. It is 22 matter.
Hmm.
The file which your lordship has now passed the order, it is of the year 2022. What is listed is 23.
So I think instead
Roster
of
is
mentioning
different.
22, they have said 23.
No, party's name also different. Manjula, worst case is,
WP number 24943 of 2023 pertains to the PDS and it's wrongly listed. List this matter.
that may be listed
WP
before the
number
roster bench,
24
your lordship.
What is that? And this matter is wrongly listed before the court. List is before the court having roster.
22, 23, there is mistake, your lordship.
Yes,
Yes.
yes, next.
Serial number 4. Serial number 4, H. Srihari, K. Srihari.
Well, it's suit filed by the husband against the wife for partition.
Counsel for the respondent is not there.
Well, it's-
Counsel for the respondent is not there.
Please.
Urgency in this?
No, stay, please.
Urgency in this?
No, stay is there, my lords. They
List
have
the
filed the
list the
application.
matter on 12th of August.
Please,
Serial number 5.
stay may be
disposed.
extended.
Huh?
Stay,
Stay.
please.
Serial number
5 is adjourned.
5 disposed.
Five
6,
it is
6
already-
adjourned, 7.
5?
5 disposed, sir. Dismissed as
Disposed.
in. Serial number 7, PM Sidmalappa.
7, 20, 25 matter. Let it come tomorrow, 25 matter.
Till number 8.
Please, I appear for petitioner, my lord. Petitioner is challenging, my lord.
This also tomorrow.
Please.
Till number
25
9.
Order is annexure A, page 18.
What to do? All the clients of these kind are compelling the courts to pass orders.
The altogether, millet, we have paid.
No, what is happening is, no, they have no other alternative. Without paying, without coming to the court, their people are here and there, what they do?
There is no disclosure of payment of money at all. 16 lakhs we have paid.
Where is the order?
Millet, kindly see, millet, the annexure 8, page 18.
Page?
18.
80.
18.
Hmm.
The petitioners
What
have.
is the order?
It is an application filed to issue a lookout circular, and that came to be allowed. Even millet, the attachment order has been passed. And I have paid millet for about 16 lakhs 61,975.
To see the order where the lookout circular is issued.
This is the order.
Where?
Page 20 is the operating portion.
Page 20?
Is the operative portion. Application filed by the petition is allowed. Issue a lookout notice.
Asking which page? 20?
20 starts from page 18, 18. Starts with sir, annexure A, page 18, order portion.
Are you referring to this?
It's serial number 9.
Next to that, my lord, that is there next to that.
Till number 10 na 9 sir.
9. ನೀವು ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಿ?
10 I called out 10 9 ಅಂತ ಕೊಡು.
Confusion.
Sorry. One 8.
Yes, please.
Yes.
Read the order.
The petitioners have filed the application praying for an issue to lookout circular against the respondent. Heard the argument, perused the contents of the application, order sheet and the documents available on record. The petitioner have filed the present petition under section 125(3) of the Code of Criminal Procedure, praying so and so. The recovery of maintenance to be allowed. As per the said order, the respondent has directed to pay maintenance of rupees 10,000 per month to the first petitioner from the date of the petition, and the 10,000 each in favor of the petitioner 2-3 till the completion of their education. The respondent has been further directed to pay annual educational expense to the minor petitioner at the cost of 15,000. After filing of the present petition pending this proceedings, even portion of the amount has not been recovered. Kindly note from the respondent. The FLW came to be issued against the respondent, returned unexecuted, stating that he is working in abroad. As per the order dated, so the property jointly appearing in the name of the respondent has been attacked through the deputy commissioner. In furtherance of the said order, Tahsildar Mulki so and so. A report along with the RTC extract showing the entering encumbrance in column number 11 of the document. The respondent is due to the petition claim.
So, how much is the amount?
According to her, 32 lakhs 15,000. Even before she files a petition under section Domestic Violence Act, section annexure F, page 49.
Have you represented before the court?
In this 125, I have represented annexure B.
Recovery proceedings.
Recovery petition, I was working there, I did not.
What is the address furnished by the?
Please, Millet.
What is the address furnished?
Address she has furnished the same in Mangalore.
You have any roots in Mangalore or not? That address is available.
Available.
Then you must be knowing that execution is filed.
Execution petition is. Even the execution petition is filed. I am paying the money. Millet, kindly annexure H, page 62.
No, the point is not whether you are paying or not. Have you completely paid or not?
Please, Millet.
Have you completely full and final settlement is done or not?
I have not paid. I have paid up to 16 lakh 61,975.
Another 14 lakhs still need to be paid.
Yes, Millet. I have operated due to medical exigencies. Millet, I have to come back. Millet, I have produced the document to show that I have got operated annexure K, page 78.
No, what is the option left to the FLW?
Section 421 of the CRPC.
I understand. Why are you not doing it? Why are you not paying it?
Millet,
no, even to recover it in that mode,
yes.
You are not available. You stay in Kuwait. What's the court do? No, they're having no other alternative. They're doing.
No. The court
whether they have jurisdiction or not, we will look at it later. That's a legal point, that I understand. When you're coming before the courts, pointing out at an order passed by the court saying that it is legally incorrect, how are you correct? How are you correct morally?
Morally, I may be wrong. The lordships are right. But insofar as
Legal aspect we will see, legal aspect we'll see. But now the court, the whole endeavor of the court is not to punish you, to see that the order is executed and the person who has the order gets the money.
that is why my alternative submission for an execution, the property is at recovery of sale, it can go on. The deputy commissioner
You're
is
sure
already
that-
ordered.
Because you're sure that no properties are there.
No, it is already there. It has been attached. I have produced the RTC. The
But to
deputy
show your
commissioner can
bona
sell the
fides,
properties.
to show your bona fides and to stay this order, what is the amount that you're going to pay on some condition? That can't be.
I am here at a writ court where the lacks jurisdiction. Once it comes in Lord, the trial court can take care even for impounding of the passport. Even for importing the passport or putting forth the condition where Millard.
Counsel, I understand the legality of it. Understand the legality of that. But you understand the legality of that. But you have to also tell what is that, how it is. You don't appear before the executing court.
Now,
You don't pay the amount. What
now
to do?
kindly a situation where Millard, it is not a case of non-payment at all. It is a
It is
case
not-
of payment.
It is not any favor, either non-payment, half payment, it still amounts to due.
It has been challenged. That order came to be challenged in the revision petition before this honorable court by filing a RPFC. That,
Interim order is there.
no, that has been dismissed for default. That is
So,
where.
please get instructions from your client. I'll take up this 10 tomorrow, 25 matter.
Cell number 11. 11. Recharge.
This matter on 1st of September.
Cell number 12.
Well, also first.
Cell number 13.
Yes.
For responding,
Yes.
go for calculation, look into it and file law.
You have filed the memo of calculation.
Yes.
Then counsel the petitioner has filed the memo of calculation. Then counsel the respondent wants to get instructions in this regard. This is the matter on 12th. 12th, next.
Cell number 14. Syed Khalil Pasha.
Yes, what is this? Interim order extent. Yes.
Hearing order passed, my lord. Post petitioner is paying 5,000.
Interim
Second
order is
and
being complied with.
Please, Your Lordship.
Interim
I
order.
could not contact my party, Your Lordship.
It is submitted that the land counsel the petition that the interim order is being complied with, land counsel the respondent wants
no
to get
interim order.
instructions.
no interim order.
No interim order.
Not interim order.
Then why you saying interim order comply?
No. Petition, trial court I will submit.
List the matter on.
Husband's challenge, Your Lordship.
List the matter on second of September.
Cell
Yes,
number
15.
15. Rachita Rajshekar.
Appearing for the petitioner, my lord. It may be taken up any date next week, my lord.
List on 13th.
My lord, next week, any date, my lord.
6th.
Much obliged.
Cell number 16. Sampath A. For petitioner.
28th August.
Cell number 17. Silmaderin B Group. Kalyan Basuraj.
Here for petitioner in this matter, my lord.
Yes, first of September.
Cell number 17. 18. Cell number 18.
2nd of September.
Cell number 19.
Which one? In all the matters, interim order will be extended wherever it is. Next.
19.
It was granted on 5/3/2025, my lord. Up to that, I have paid the amount. They have filed the execution.
This
That
is matter on 3rd of September. Yes.
Cell number 20.
I'm for the respondent in this matter, my lord.
Be listed any
Originally,
and
they made a submission last time that hand summons were served.
Yes, and a memo was filed to that extent, Your Honor, and that has been taken on record as well.
This
On
matter,
20th.
originally this matter was filed under
Minus
adult.
it could be
cruelty.
adjourned to next week.
I can say what he wants to say.
I'm for the respondent in the court below. I've completed the cross-examination and it's also for cross-examination of RW2. Now they come up with this application for documents from a third party and without filing recall reopening.
2022, they filed this matter, my lord. Until date, they are dragging this matter and there is an interim stay on this matter. And it's going on and on.
But it could be listed next week, Your Honor.
Till number 21.
Yes, my lord.
In this matter, my lord.
Kindly cease for adjournment.
Interim order is there, it may be extended. my lord.
This matter on 10th of September. Interim order earlier granted is extended.
Number 22.
Mother filed the petition for seeking the maintenance from the son. His interim maintenance fixed at 5,000 rupees. I filed this petition for enhancement of the.
You have been complaining.
Lord,
Who is appearing for whom?
Respondent, I'm opinion.
You are for the,
Respondent.
and you say that you're complaining that
Lower
interim
court
order
order.
is.
Lower court order is
That's sought
the.
for enhancement.
Yes, list the matter on 6th of August.
Till number 23. Tejas.
Yes, this also same day.
Till number 24.
This matter on 14th of August.
Till number 25.
Interim order may be extended.
In all matters, it will be extended. It's
25. Chandana Tariga.
interim order in this.
But, I may be permitted to withdraw the amount in deposit because she is a respondent wife.
Lanka, as per the order passed by this court, the
My
petitioner
lords,
has.
I appear for the petitioner in this matter, my lords.
Yes, he wants to withdraw the money that is deposited.
My lords, after arguing the IM, my lords, on seeing the merits, my lords, it was directed that it be deposited in the registry, my lords. I have been diligent in paying their monthly maintenance as of now, my lords. The petition, the respondent as such, my lords.
Let it come on Monday, I'll hear it on
Whenever
Monday.
the matter comes, they take the time and they are not
Monday.
allowing us to withdraw the amount which is in the deposit. How she has to survive?
Monday.
My lords,
Yes.
Monday, it could be heard, my lords, kindly.
Matter may not reach, my lord, because too many matters are in this case.
Monday it will come, Mr. Counsel. You're waiting from 24. Sudden urgency in 25, you can't call. And that too, as this court has directed the matters, they are listed. Otherwise, they wouldn't have been listed in the.
That is there.
So please wait.
Yes.
27.
next.
Prasanna Kumar
bless.
Arad.
Petitioner in this matter. Respondent, my lord. The interim order has been complained, my lord. 29th may kindly be taken up.
29th.
Tuesday.
29th.
Till number
Public.
28. Venkat Reddy, SPM.
The respondent, day before yesterday, your lordship heard me, my lord. The other side was supposed to submit. They were submitting
Tomorrow.
certain citations, they are not supplied.
Tomorrow.
Tomorrow is, there is an inconvenience. There'll be a direction to furnish the citation which they are laying upon.
Just, let us-
30th.
yes.
Interim order may kindly be extended.
29.
Till number 29.
Respondent, you have not completed interim
For
order.
the petitioner, my lord.
You have not
29.
Respondent, you have not completed interim
For
order.
the petitioner, my lord.
You have not completed interim order. You have not completed interim order.
IO may be extended, my lord. Interim order may be
Responding.
extended. For the petitioner in this case.
What do you want?
You have not completed interim orders till
They are
today.
not complied. Yes, have you complied with the interim order or not?
Yes, my lord.
Only
When counsel
5,000.
for the petitioner submits, a respondent submits that the interim order is not complied with. If the interim order is not complied with by 30th, the stay granted by this court stands vacated.
Serial number
It is
27.
complete,
Lord, serial number 27, Lord, may kindly be ordered to be listed in the parted.
It will come.
Lord.
Yes, 30.
31.
Same date.
25 September.
Yes.
23rd.
32.
Till number 32.
There are affidavits is filed there.
This matter tomorrow, 32 tomorrow,
May request Tuesday, my lord, if it's not inconvenient.
Tuesday. 32
Obliged.
Tuesday. Yes.
29. For judgment, till number 33.
I appear for the respondent in this matter, my lords.
Matter on Tuesday.
Much obliged, madam.
Till number final hearing 34.
This 34 and 35 also Tuesday.
Yes, ma'am.
But if it can be Monday, that's
Monday.
request Monday.
Yes, Monday.
Much
It may be listed 30. I appear for the petitioner in 34, my lord. It may be listed 2 weeks after.
No, it's all 14 matters. They can't be adjourned more than this.
35, 29, 7.
35 Friday, Lordship.
No,
My lord, there has been long delay in 35,
Monday,
serial number
Monday,
35.
Monday.
Monday for final hearing.
yes, done. Signatures. In all the matters, wherever stay is there, please extend.
Your Honor, may I please request one thing?
Are you a party in person?
No, just now my case was heard, madam. The date was given as 22nd, but
Are you a party in person or you have an advocate to represent?
I had
Your
a,
advocate is there, you cannot represent before the court.
Madam-
Ask your advocate to come.
madam, my problem is that date was given 22nd. I am not in Bangalore. I had,
Advocate to come.
madam, my problem is that date was given 22nd. I am not in Bangalore. I had already told him that please take the date after 28. But mistake happened and he accepted 22. I could not speak. So I would request, madam, because I am not in Bangalore since morning I am here, please change the date to 28, 29, 30, any date. Please.
22nd of which date you're, 22nd of which month you're thinking?
22nd of August has been given because the family court is passing order on 21st of August. One day later, you have given, Your Honor. I request 28, 29, 30 because I am not in Bangalore. That's why.
Look at it, 29, and hereafter, you can never represent before the court. Let your advocate be there.
Thank you very much.
No, only one restitution of conjugal rights, and we have for DV Act, only one case has been dismissed. Both the case has been not dismissed. Kindly post it for tomorrow.
Which one, sir? Serial number?
Serial number one, list number 124. Serial number
124.
4.
124, only one case is there and it becomes interesting.
Only one case is there. There are no two cases in that.
In lower court, only one, both 2 cases are there.
Yes. Anything else?
ಅವ್ರು ಯಾರ್ದು ಅವ್ರು ಹೊರಟೋದ್ರಲ್ಲ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಎಲ್ಲಿ ಅವರು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಯಾವ್ದಂತ ನೋಡು
Court officer. Court officer. Madam, ಒಂದು ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ ಕೂಡ ಕೇಳಿದ್ರು. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್.
Yeah, because everyone is. See, just now in front of the lawyer, he agreed to stay back and amazing.
He filed tomorrow.
He will not come. I have a feeling.
He said Monday, okay.
Yeah. Oh, yes.
Court officer.
I sent it to you on WhatsApp. Anything else you want? So I will go and come back in 45 minutes. It's 5:30. I'll come back by 6:50.
Carry on.
Thank you.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮಾತಾಡೋದು?
ಸರ್ ಏನ್ ಬೇಕು ಹೇಳಿ.
ಮೇಡಮ್ ಅದೇ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಂಬರ್ ಕೂಡ ಕೇಳಿದ್ರು ಮೇಡಮ್.
ಯಾವ್ದು?
ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಮೇಡಮ್.
ಅವರು ಬರ್ಕೊಟ್ರಮ್ಮ 2 ನಲ್ಲಿ ಅಲಾಂಗ್ ಬಿಟ್ಟು 29/7 ಬಿಂದು ವೆದರ್ ರಿಟರ್ನ್ ಅಲಾಂಗ್ ವಿತ್ ನಂಬರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಗೆ ನಂಬರ್ ಬರ್ಕೊಟ್ರ ಲೇಡಿ ಹುಡುಗಿ.
ಇಲ್ಲ ಇಲ್ಲ
2 ಅಲಾಂಗ್ ವಿತ್ 29/7 ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ನಂಬರ್ ತಗೊಳ್ಳಿ ಅಂತಲ್ಲ ಅದೇ ಅದ ಲೇಡಿ
ಎರಡಿದೆ ಮೇಡಮ್, ಎರಡಿದೆ.
ಹಾ ಹೇಳಿ ಸರ್, ಹೇಳಿ ನಂಬರ್ ಹೇಳಿ.
WP ನಂಬರ್ 21148/25.
ಸರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ, ಆಮೇಲೆ ಸುಮ್ನೆ ರಾಂಗ್ ಆಗಿ ಲಿಸ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ. ಸರಿಯಾಗಿ ಹೇಳಿ. 2
ಮೇಡಮ್ 21148/25.
ಆಮೇಲೆ
15181/25.
15181/25. ಎರಡ್ ನಂಬರ್.
ಎರಡು ಕೇಸ್ ಇದೆ ಮೇಡಮ್ ಅಷ್ಟೇ. 21148 ನಮ್ದು ಮೇಡಮ್ ಅದಕ್ಕೆ.